I'm the victim in a case that I filed a case, CRLMC number 1701 of 2022.
Where's the memo? What are you mentioning? You have to give a memo, sir.
Your Lordship, my life, my right to life, liberty, justice has been curtailed and increased. So, can I file it after lunchtime?
Sir, there is a procedure, sir. Why don't you follow the procedure?
Well, let me to say, I have no time. I've been in confined zone in the territorial jurisdiction of this the Odisha state. I've been tortured by the state of Odisha, by the entire police, by many bogus, wicked advocates of some particular, even of the High Court of Orissa advocates and the Baleswar District Bar advocates. So, many judges are involved in my case. Where should I go? Whether I should go to the Honorable President of India or where else?
Is this being live streamed or something?
I've been
on behalf of OP number 6, my lords. In the meantime, the management has changed, my lords. So I need to seek some instructions and I will file an affidavit.
What we can do is we can impose exemplary costs on you. We'll quote the order of the Supreme Court, but we impose exemplary costs, sir. You pay the costs for today's adjournment. Because tomorrow the Supreme Court should not say why its order has been violated. All right. Whatever reason, whatever excuse may have, we will record that, but you will have to pay costs, sir. Exemplary costs. All right.
Pardon, my lord. Last chance, my lords. 2 weeks' time.
That order was passed on the request of OP number 6, my lord. And he has said that there is change of location, my lord. My stand is clear, my lord. They have challenged the notification, fee concession notification, my lord.
So let him first face his case, then we'll hear you.
Yes. The petitioner is a petitioner educational institution. It's located within 3 kilometers of the toll plaza. As for the notifications of the NHA, there is a monthly fixed charge is to be paid for the buses to cross the toll plaza. Instead of receiving that, they are charging higher, for which I have approached your lordship. So my case is covered by their own NHA circular, and that I am lordship drawing your lordship's attention to page 164 of the petition, Annex 3, mail. Monthly passes for, has your lordship got it? Yes.
See, the difficulty is he's claiming that the situation on the ground has changed.
That they are not bringing. I just tell you to assist your lordship. The place where the toll plaza was situated at the time when I filed the applications has been now shifted, admittedly. But the institution is in the middle. So previously, once its boss was flying towards south, it required to pass.
Sure. Yes.
Yes, madam. Previously, the institution was, while flying towards south, it was required to pass the toll plaza at the time of challenge. Now, while moving towards north, so on both the sides, students are being picked through the buses. So in any case, I have to pass. For one location, I'm not going to pass, but for the other locations where I have to pick the students, I have to pass. And that is the higher education department has also obligated me that I cannot charge beyond a prescribed fee towards transportation. Now, my predicament is that there is a upper capping fixed by the government of Odisha so far as charging the transportation fee towards from the student is concerned. Now, these are buses, educational institution buses. It is coming within 3 kilometers of the establishment. Otherwise, also local residents are being given concession.
What was the interim order against which you went in appeal?
I have not, they have went in appeal.
What was the interim order?
The interim order is allowing that I should be paying 1,000 rupees per month as per that circular. That is dated, my lord, 9th of May 2012. There is another writ application in which the detailed order has been passed, but that circular dated.
So they've stayed the enhanced toll.
My lord, that I'm directed to pay 1,000 rupees per bus per.
So we can do one thing.
My
Since this order has continued, the stay has continued for 10 years now.
My lord.
So if they let them redo the entire exercise.
No, my lord, let it continue because that.
It will continue till such time they redo the entire exercise. They need to redo it. If at all they need to redo it, we don't know. If according to them, situation has changed, then there'll be no need to redo it. If they think they have to redo it, they'll do it in a proper procedure in accordance with law under the Act.
Rule 9, my lord, he can make an application.
No, my lord.
Rule 9 deals with discount.
So this stay will continue.
What I am saying, my lord, once your lordship ask me them to let them do it on the basis of the 5th August 2002 circular. I have no answer. If my one
Whichever circular, sir, whichever order, they let them apply all that and to redo it.
But
basically, we're asking to redo it.
They redo means the National Highway Authority. Otherwise, the toll this is a private company. Now the opposite party.
Obviously, it's NHAI, sir.
As per their circular dated 5th of August.
All right. You say on 9th May 2012, the following order was passed in Writ Petition Civil 624 of 2012. Reproduce the whole order. The above order was challenged before the Supreme Court of India. The above order, along with the orders.
In this order, the Honorable Apex Court has refused to grant stay.
Writ Petition Civil 31946 of 2011. Questioning the same toll fee notification for the same toll plaza were challenged before the Supreme Court of India in 4 civil appeal numbers 5744-47 of 2015. Full stop. On July 2015, the following order was passed in the said civil appeals by the Supreme Court. Reproduce that order. It's right on top of the file. Paragraph. For some reason, these cases were not listed before this court till 10th August 2022, when the following order was passed by the court. Paragraph. Today, both counsel appearing for NHAI as well as opposite party number 6 seek more time to file an affidavit. Full stop. As already noted, the Supreme Court had, in its order dated 27 July 2015, requested this court to expeditiously dispose of the writ petitions. Full stop. Nearly 3 months, more than 3 months ago, time had already been granted to both parties, to both the aforementioned parties, to file their respective affidavits. Full stop. In the circumstances, the court does not consider it reasonable to grant them further indulgence in the matter. Paragraph. As already noted, the order dated 9th May 2012 passed by this court
is in operation, my lord. No stay has been granted, it is in operation. Insofar as the present petitioner is concerned.
The interim direction passed by this court not to collect toll fees from the buses of the petitioner in Writ Petition Civil 624/2012 is continued for over 10 years. And the Supreme Court of India is also not, was also not persuaded to interfere with that order. Paragraph. Consequently, since that arrangement has continued for over 10 years now, the following directions are issued. And considering the submission of both NHAI and OP number 6 that the toll plaza has already been shifted from its original location, and therefore there is a change scenario, the following issued. 1, the interim order staying collection of enhanced toll fees from the Petitioner Interpretation Civil 624 of 2012, and generally there is stay in the other writ petitions also, right?
No, my lord.
Only in yours. Yeah.
That stay has been interfered with by the Honorable Apex Court.
I see. No, the interim order passed by this court shall inure to the benefit of the.
That is the Apex Court's interim order.
Which is what?
My lord. There are 4 civil appeal. Out of the 2 has been filed against the present petitioner. In those 2 SLPs, no stay has been granted.
What is the stay granted in the other 2?
The stay was they have to deposit the money that they have to the stay has been granted. So it was conditional that insofar as the excess collection has been called upon to be deposited.
What happened to those writ petitions? Where are those?
Writ petition is already
Disposed of, is it?
Yes, it is disposed of as non-prosecution because
That has been dismissed for default.
the council
Dismissed for
appearing in
default.
that matter.
Record is calm.
All right. You say the interim order passed by the court staying collection of toll fees from the Petitioner Interpretation Civil 624 of 2012 will continue till such time the NHA undertakes a fresh exercise of fixing the toll fees in accordance with law. That is under Rule 9 of the
9 of the National Highways Determination of Rates and Collection of Rules 2008.
just ask him to collect it. Just keep it this.
Sub-rule 2 of Rule 9.
You've given us National Highways Tribunal Procedure Rules. Sir, you've given us National Highway Tribunal Procedure Rules.
National Highways Determination of Rates.
What is this, sir? What is the correct rule?
It's my mistake, my lord. I used the wrongly.
This is not applicable. No, but read it. That's not even applicable. This Rule 9 talks of discounts.
Yes, madam.
I'm not on that.
Who's talking of discounts?
I'm not.
They want discount on the basis of that notification, my lord,
No,
which
no.
has been superseded
No.
by another notification 1910.
No. I'm on 5/8/2002.
5/8/2005.
A driver, owner, or person in charge of a mechanical vehicle which makes up the section of the national highway.
Yes.
This is not some owner of a very mechanical vehicle. I don't know if this applies at all, sir.
No, my lord, it's not up. It's their stand in their company.
Sub-rule 1 also, the executing authority or the concession, as the case may be, shall upon
I
request
think
provide a
9(3) might apply, sir. 9(3).
9(3), yes, person who owns a mechanical vehicle. Yes, madam.
This might apply.
Yes.
Ah.
Sorry. No.
Or
Subsequent.
redetermine the toll fees in terms of Rule 9, bracket 3 of the National Highways Fee, bracket determination of rates and collection, bracket rules 2008. For this purpose, a proper procedure will be followed by inviting objections to the proposed draft proposal from all concerned, including the present petitioner, by giving them sufficient time and giving them a hearing before finalizing the fresh revised toll fees in accordance with law. 3, the above exercise be completed within a period of 6 months from today. 4, it is reiterated till the exercise is completed. The interim order passed by this court, as affirmed by the Supreme Court, will continue. Petition is disposed of in the above. Other thing you say, while the Supreme Court interfered with the interim orders in the connected writ petitions, it is not in dispute that those connected writ petitions have already been disposed of. Full stop. The only surviving matter is the present writ petition, in which no stay was granted of this court's interim order by the Supreme Court. This you have to insert it earlier.
To treat petitioner educational institution, I paid 2002 the exemptions notifications.
Sorry?
The exemption notifications of the NHAI in which they have fixed the monthly fee. That is what I'm saying.
Considering all notification will decide.
So they have to do a fresh notification.
Yes.
That's what we have issued directions for.
Item number 2.
Item 2 may futures. But here the petitioner has initially challenged the recovery from his salary in the during pendants, my lord, died, my lord. Thereafter, my lord, his legal heirs were substituted. The question is that he was supposed to get 18 lakhs towards his, my lord, retailer benefits, my lord. They have deducting an amount of 7,85,687. They have paid him paid 6 lakhs, my lord. The case is, my lord, he was given a show cause for loss, my lord. I gave a show cause reply. And under Annex 6, your lordship may kindly see at page 17, the State Warehousing Corporation, they themselves admit that there is no loss. Last paragraph of that letter, your lordship got the Annex 6.
Yes.
The last paragraph, my lord, the empty gunny has consumed collection of the spilling of the minimized SL, for which if the permission is to be taken, the grains lying on the floor would get damaged. For abnormal losses, the district officer recovering such and such amount, but the FCI Bhubaneswar is claiming 2,000 such and such per quintal, where the case from 9 to 11/9 had already been written off. This SL, the rest period is well within the permission. Question of recovery of SL quantity of such and such amounting to such a does not arise at all. It is within the permissible, my lord, limit of loss. Now, next page, the FCI, my lord, collected that amount from the warehousing corporation. Since the FCI has deducted the amount, they have deducted the amount from me, my lord.
Who's for the FCI? Oh, sorry, State Warehousing.
No, I'm appearing for Mala State Warehousing Corporation. In fact, Lordship, last occasion, 2 occasions, wanted the FCI should appear and explain with regard to Annex 7. But be that as it may, Lordship, in page 17, my learned friend, in fact, he has mentioned that letter. And the 2 occasions, Lord, they are not appearing. Pursuant to FCI's letter, in fact, what is a State Warehousing Corporation recovered that amount. That's true.
No. The question is as far as the predecessor in interest, because that man has died, it's his LRs who are on record.
That's correct. Substituted.
Was any opportunity granted to him before passing this order? One minute, sir, we are asking him.
Sorry.
That's correct. My learned friend is correct. In fact, no opportunity are given.
So we'll set it aside. If you need to recover, you follow a
7. Annex 7 is to be set aside because that's to be uncontroverted. The reason is, my lord, page 17, Warehousing Corporation said that the limit is there. Page 20, SCI a calculated limit, page 20. And our reply is, my lord, yes, that is beyond the yes. That is why it's not, FCI is not correct. So you can refer page 20 and 17.
The challenge in the present petition is to a recovery notice dated 6 November 2012 issued by the Orissa State Warehousing Corporation bracket OS to the petitioner, the original petitioner bracket who has died during the pendency of the present petition and has been substituted by his legal representatives bracket LRs bracket and close big bracket on 6th November 2012, requiring him to deposit a sum of rupees 788,147, claiming the value of stock of grains belonging to the Food Corporation of India bracket FCI, which purportedly were lost on account of alleged laxity and negligence of the late petitioner, who was at the relevant point in time the deputy superintendent and warehouse in charge, OSWC, Nayagad. Would stop. While issuing notice in the present petition on 18 March 2013, an interim order was passed staying the operation of the aforementioned letter dated 6 November 2012 and directing that no coercive action pursuant thereto shall be taken against the petitioner. Full stop. That interim order has continued till date. By an order dated 15 November 2021, the LRs of the deceased petitioner were brought on record. Full stop. On 20 July 2022, an additional affidavit was filed by the LRs of the petitioner, enclosing a copy of a letter dated 18 July 2018, whereby a sum of rupees 1151,987 was recovered from the contributory provident fund dues of the late petitioner. Full stop. At that stage, Mr. Vijay Kumar Das, learned counsel appearing for the OSWC, had sought time for instructions. Full stop. Thereafter, the OSWC has filed an affidavit dated 19th October 2022
In paragraph 7, my lord, in the counter, they have admitted that it is within the permissible limit.
In paragraph 7, yes. Yes. Yes, in paragraph 7.
7 or which counter?
My lord, their counter affidavit.
My counter affidavit, paragraph 7.
The counter that they filed in the month of October, my lord. In paragraph 7, they have admitted that with regard, may I read that, my lord? With regard to the amendments made in paragraph, the read petition application is specifically submitted that the petitioner has admitted committing irregularities at Annexure 5, that the weight check memos could not be verified due to non-availability of the same, although the storage loss for the relevant period shown by him did not exceed 0.5%, which is within the permissible limit, that is 0.2 and 0 to 0.3%.
Affidavit filed, sorry, in an affidavit filed on 19/10/2022 by the OSWC, it has been stated in para 7 as under. Take bottom of page 37, top of page 38. Paragraph is separate. Affidavit has been filed with FCI.
FCA not filed.
FCI have not.
FCA not filed counter in. FCA not appeared.
No, 19th August 2013, there
No.
seems to be an affidavit of FCI. Admitting that a demand notice was issued to OSWC through its official representative, open quotation, and not to the petitioner in his individual capacity. Unquote. However, thereafter, no affidavit has been filed by the FCI. Paragraph, a further affidavit has been filed on 19/10/2022 by the OSWC, confirming the withholding of various sums from the late petitioner. But without disputing that no prior notice was issued to the late petitioner before effecting such recoveries. Paragraph, it is reiterated by Mr. Dash appearing for OSWC that the aforementioned withholding of amounts was made only on account of the letter dated 22nd August 2011 of the FCI, which was preceded by another letter dated 28th July 2000 regarding permissible storage losses. Paragraph. Having heard learned counsel for the parties, having heard learned counsel for the petitioner as well as the OSWC, and with none appearing for the FCI today, and having perused the aforementioned pleadings, the court is of the view that the recoveries effect petitioner without any prior show cause notice or seeking an explanation from him individually is unsustainable in law, as it is clearly violative of the principles of natural justice. Full stop. With the petitioner having expired and with his LRs coming on record, this defect in failure to comply with the principles of natural justice prior to effecting recoveries cannot be rectified. Full stop. The inevitable result is therefore the impugned recoveries effected by OSWC from the late petitioner have to be declared to be legal, and it is so ordered. Full stop. The sums recovered from the late petitioner will now be restored to his LRs, together with 6% simple interest from the date of the recovery up to the date of such as the monies. Which in any event should take place not later than 8 weeks from today. Full stop. Which LRs will be, you select one LR, I think.
My lord, the Vijay Lakshmi, who was shown the affidavit in this case, my lord, the LR number 1A, my lord.
The monies be paid to the wife of the late petitioner, right? Vijay Lakshmi Behra. On behalf of all the LRs of the late petitioner. All right. The petition is disposed of in the above terms.
3. I'm sorry, my lord. I'm sorry. But in the Annex 7 is the FCI's letter that should be passed, my lord, because the pursuant to that, the state various.
Once we declare it illegal, then that obviously goes. Sir. The effect of this is that Annex 7 will not be given effect. Correct.
Item number 3.
My lord, Mr. Das is not physical well. The matter may be called next week on any day.
What is the matter about, madam? When the
My lord,
wakalat has not been filed, even last time it was adjourned. 19th September, same thing happened. We won't repeatedly adjourn. Wakalat is not even filed. You say for over 8 years now, even the wakalatnama of the counsel who has filed the appeal has not been placed on record. More than 2 months ago, on 19th September 2022, at the request of counsel for the appellant, the matter was adjourned. Stop. Today, again, another adjournment is sought. Stop. Considering that the defects pointed out by the registry have not been cured for over 8 years, the court is not prepared to grant any further time for that purpose. The appeal is dismissed.
4.
1 minute. This is single bench cases 8828. You say list this petition before the roster bench of the learned single judge on 5th January 2023.
Now, may I please, Your Lordship? Before commencing with my submission, Your Lordship, may kindly
Matter in
see.
this case, Your Lordship's direction was to produce the seal cover, the result. I have produced to Your Lordship for Your Lordship's perusal. By the order dated 8/4/2016, there was a direction. And order dated 29/9/2022, Your Lordship.
The seal cover.
I have given that.
Use a scissors. Use a scissors. You can show it to them. Have you seen it? You've not seen it.
No, my lord. I have
So
not.
show it to both of them.
Yes, my lord, the remark,
If Your Lordship permit, can I also have a
Yeah,
look?
just give it to him.
Only experience selection.
They've all qualified. They've all qualified.
Yes, Your Lordship.
So only for the only question is now date of acquisition of the qualification.
Yes, Your Lordship. On that basis, this on the division bench of this honorable court, upon a judgment, Your Lordship. I'll just produce the judgment, Your Lordship.
I'll let you know. Just keep it with you. Just keep it. I will let you know.
My Lordship, I have relied upon two judgments. दे दो टिक्के वाले कही दी दे दी One is 1993 supplementary 3 SCC page 168. That is Rekha Chaturvedi versus University of Rajasthan and others. My Lordship, is kindly see paragraph 10. The contention that, I'm just placing the paragraph, Your Lordship. The contention that the required qualifications of the candidates should be examined with reference to the date of selection and not with reference to the last date for making applications has only to be stated to be rejected. The date of selection is invariably uncertain. In the absence of knowledge of such date, the candidates who apply for the post would be unable to state whether they are qualified for the post in question or not. If they are yet to acquire the qualifications, unless the advertisement mentions a fixed date with reference to which the qualifications are to be judged, whether the said date is of selection or otherwise, it will not be possible for the candidates who do not possess the requisite qualifications in presently, even to make application for the post. The uncertainty of the date may also lead to a contrary consequence. Viz, even though who do not have the qualifications in presently and are likely to acquire them at an uncertain future date may apply for the post, thus swelling the number of applications. But a still worse consequence may follow in that it may leave open a scope for malpractices. The date of selection may be so fixed or manipulated as to entertain some applicants and reject others arbitrarily. Hence, in the absence of a fixed date indicated in the advertisement notification inviting applications with reference to which the requisite qualification should be judged, the only certain date for the scrutiny of the qualifications will be the last date for making the applications. Here's my first submission, Your Lordship. Now, and the judgment of the Honorable Apex Court, that is 2007-10 SCC, page 260. Rajasthan Public Service Commission versus Kaila Kumar Paliwal and another. The part 21 of the judgment, Your Lordship. Para 21. I'm just placing the paragraph, Your Lordship. Recruitment to a post. Have you already got it?
Yes, yes.
Recruitment to a post must be made strictly in rules operating in the field. Essential qualification must be possessed by a person as on the date of issuance of the notification or as specified in the rules, and only in absence thereof, the qualification acquired to the last date of filing of the application would be the relevant date. Now, in the present application, what has happened, Your Lordship, is in the year 2014, there was a resolution by the OPEPA. Thereafter, they made an advertisement. In the advertisement, they have published a total of 16,000 posts, Your Lordship. Now, thereafter, they have fixed an age criteria to the higher age criteria for 35, Your Lordship. Now, subsequently, some of the candidates who were age barred, they came with the Honorable Court. The Honorable Court extended the age from 35 to 42. Now, thereafter, my Lordship, in 2016, there was a corrigendum. My Lordship, kindly see the corrigendum at page 48 of the appeal. Page 48 and section 5, Your Lordship. The heading is Engagement of Shikha Sahayak Corrigendum. in pursuance of order of the Honorable High Court passed in WPC number 67/2015, read with letter number so and so, and in continuation to the advertisement published by paper letter number so and so, the last date for submission of the online application for the post of Shiksha Sahayak is hereby extended for the candidates within the age group of 35 to 42 as on 30/9/14. Now, my lordship, admittedly, these applicants, they were all age barred in terms of the erstwhile advertisement. Now we were eligible pursuant to this corrigendum. Now, in this corrigendum, we have made our application, appending our OTATE qualification. Now they have rejected only on the ground that you have not qualified the OTATE prior to the last date of advertisement. Now, my cause of action arises only when they issue the corrigendum. Otherwise, I was not eligible to apply.
No, as far as the age is concerned, you were not eligible to apply. Therefore, you applied.
After the corrigendum, I can apply, your lordship.
Correct. Because of your age.
Yes, your lordship. Only for the age.
But what about qualification? You have to get the qualification by 30th September.
Yes, your lordship. Now, my lordship, after the corrigendum, we have the OTATE qualification as well as we were eligible to apply.
You got your OTET qualification only in 2015.
Yes, your lordship. Now, in terms of the Honorable Appeals Court judgment, your lordship, my qualification has to be adjusted when I have made the application.
No.
That's what I was saying, your lordship.
Date mentioned.
There was no date. There was no date in itself.
Let's read that para 21 of that state of Rajasthan Public Service Commission.
Yes, your lordship.
Recruitment to a post must be made strictly in terms of the rules operating in the field.
Yes, your lordship.
Essential qualification must be possessed by a person as on the date of issuance of the notification or as specified in the rules, and only in the absence thereof, the qualification acquired till the last date of filing of the application.
Yes, your lordship. That was a specific case.
So the last date for filing this application is 28 February 2016.
Yes.
In terms of the corrigendum.
Prior to that, I have already qualified the OTATE examination.
Can't be. Yeah, because he won't even apply then. If it has to relate back, So for their kind of cases, it can't relate back. So for a case of a person who was earlier age barred, now because of the corrigendum, he becomes qualified to apply. How can it relate back to the original date, sir? Then we're defeating, because the single judge seems to say that the corrigendum relates back to the. If the corrigendum relates back to the original date, this age increase can never be given effect to.
My lord, may kindly see for your lordships what my learned friends read it, but not read complete that document that a corrigendum, page 48 of the writ of appeal. I'm reading from the where my learned friend has left. The last date of submission of online application for the post of Shiksha Sahayak is hereby extended for the candidates within the age group of 35 to 42 as of 2014, with relaxation of 5 years and 10 years PH candidate, those who were not able to apply due to age specification.
Correct.
My lord. So, date eligibility condition, all other eligibility condition, as on the date of original advertisement, that is to be taken.
No. So for a person who has not qualified originally, if he has acquired the educational qualification in the meanwhile, because if you look at this one, there is no rule. Here also there's no rule.
And yes.
In the absence of a rule, judgment says, just see para 21. In the absence of a rule.
You have the judgment.
No, that document.
I'm sorry, your lordship. I will give him the copy, your lordship.
Here the recruitment, my lord, there is no rule.
Para 21 you read.
Yes, I am seeing that. Para 21. recruitment to a post must be made strictly in terms of the rules operating in the field. Here there is
Go on.
essential qualification must be possessed by a person as on the date of issuance of notification or as specified in the rules, and only in absence thereof the qualification
So
acquired.
in his case, the notification will not be the original notification. The notification will be the corrigendum. Because only because of the corrigendum he could apply. So in his case, this date of notification can't be the original notification. It can only be the new notification.
No, that corrigendum was issued.
So then
Was from the order of the Honorable Court.
the qualification should be obtained on the date of the notification. In his case,
Yes.
will mean date of corrigendum.
But the guideline governing the field of recruitment for a Shiksha Sahayaka, that is 6/8/2013, that has to be followed.
Yes, we have qualified
That-
state
So
examination.
Their
that
qualifications-
doesn't say that irrespective of corrigendum,
Yes.
the original notification should be the date. In fact, it is silent on what happens when there is a corrigendum.
And your lordship kindly have a glance to page 21 of our counter.
Yes.
That counter was filed on 14/8/2019,
Yes.
para 21.
Yes.
That is a clarification regarding consideration of the candidature for the post of Shiksha Sahayaka in 4th and 5th preference district. My lord, may kindly see the last portion. The qualification acquired by the candidate after 39/2010 will not be taken into consideration while preparing the merit list.
That's right. This
But
is because
this has not been challenged.
not for challenge. This was at the time when no corrigendum, the corrigendum was, this is
Yes.
why this is why they're in court, sir. Because of this understanding, they're in court. It is because of this they are in court. It is because of this they were disqualified.
But in,
They were disqualified because of this, sir.
yes,
Which is why they have come to the court.
no, my lord, they were the age bar.
Why have they come to the court, sir? Not because they were age barred. That was the earlier writ petition. The court already increased the age. As a result of increase in the age, corrigendum already issued.
Yes,
Now why have they come to the court? They've come to the court because of this kind of clarification that you have issued.
yes.
So what's the point in
That is the
referring to that?
present
We are
writ appeal
examining the
application.
correctness of this. This is not cast in stone. This is not a rule.
My lord.
This is your understanding. This is what is being challenged.
Yes.
All right. You see the appeal.
But my only my addition to your lordship's my submission would be that with regard to selection of Shiksha Sahayaka, that regulation 6/8/2013 has to be followed.
Regulation?
That is 2013. We have annexed that annexure B/4, page 11. Guidelines for engagement of Shiksha Sahayaka.
This is just a guideline.
Yes, that procedure we have to follow.
No, but how does it deal with the corrigendum?
But the corrigendum is only in response to the order of this.
What does this guideline say?
That was the one thing.
What does this guideline say in respect of corrigendums?
No, in respect of corrigendum, there is nothing.
So there is no guideline then.
The guideline is
There is no
of
guideline.
2013.
There's no guideline for what should be done when there is a corrigendum.
No, that is not.
You said the challenge in the present writ appeal is to the order dated 24th February 2016, passed with a single judge, dismissing writ petition civil 3138 of 2016, present 3 appellants. Praying for a direction to the opposite party department of opposite party, that is the Orissa Primary Education Program Authority, and the School and Mass Education Department, bracket SME Department, bracket Government of Orissa, to permit the appellants to participate in the selection process for the post of Shiksha Sahayak pursuant to an advertisement dated 12th September 2014 and the subsequent corrigendum dated 9th February 2016. And if selected, to engage them as such. So by the impugned order, paragraph, the background facts are that each of the appellants acquired the B.Ed degree and thereafter appeared in the Odisha Teachers Eligibility Test, bracket OTET, paper Romans 2, conducted by the Board of Secondary Education, Odisha, in December 2014, and the results for which were published in the month of March 2015. Paragraph. There were two guidelines issued by the S&ME department regarding engagement of Sahayaks. So the first guideline was dated 6th August 2013. Where inter alia, it was stipulated that which is a particular guideline
One is
in 6
Page 11 of our counter.
one is 6/8/2013, another is 11th of September.
No, so which clause of 6/8/2013?
They're relying
Clause
upon
5 category 2.
it's clause 6.
Sorry?
Clause 6 category 2. Clause 6 category 2.
Sorry, clause 6 category 2.
Where clause 6 category 2 prescribed that the candidate should have a pass in OTET category 2 among other qualifications. As far as the age was concerned, the candidate had to be not below 18 years and above 35 years. And in case of SC/ST women, ex-servicemen and SCBC, the upper age limit could be relaxed by 5 years, and in case of candidates by 10 years. Paragraph. On 11th September 2014, a revised guideline was issued regarding engagement of Sikya Sahayaks during 2014-15.
11/9/2014 is the
As regards the age limit, it was to be determined as on 12/9/2014, open quotation, i.e. the date of publication of the advertisement, unquote. It transpired that as regards the non-relaxation of the age for specified categories of persons, writ petition civil number 6670 of 2015 was filed in this court, in which this court passed an order on the date of the High Court order.
High Court order.
February 2016. Page 15.
Must have been, I don't have the date of the High Court order.
No, I think it has to be earlier than that, sir. Because it says in pursuance of order of High Court passed and so and so, read with letter dated 4/2/2016. Along with a letter dated 4th February 2016. The open quotation, last date for submission of online application for the post of Sikya Sahayak is hereby unquote, was extended, open quotation, for the candidates within the age group of 35-42 as on 30th September 2000, with a relaxation of 5 years for SC /ST SCBC women and 10 years for PH candidates. Full stop. It is only by virtue of this corrigendum, which provided for the relaxation of the upper age limit, that the three writ petitioners, bracket, the appellants here, bracket, became eligible to apply for the post of SS. Full stop. Under the earlier notification dated 30th September 2014. No, 11th, is it? Yeah. Early notification dated.
Master, the advertisement is of 12th September 2014.
Advertisement dated 12th September 2014. They would not be eligible. Full stop. In terms of the corrigendum dated 9th February 2016, the last date for submission of the application was 28th February 2016. Paragraph. While the appellants contended that they had possessed the requisite qualification of OTET-Roman capital 2 in March 2015, which is before the last date for submission of applications in terms of the corrigendum, their candidature could not have been rejected on the ground of lack of requisite qualifications. So the stand of the SNME department, on the other hand, was that it is only for the purposes of determination of age, as per the enhanced age criteria, that the relevant date was fixed as 30th September 2014. So the qualification also had to be obtained as of that date. Stop. The learned single judge appears to have accepted the plea of the department that the corrigendum related back to the original advertisement itself. Therefore, the cutoff date for determining whether the candidate has possessed the necessary qualification had to be the same date fixed for determining age, which is 11th September 2014. Paragraph. Learned counsel for the appellants has drawn attention of the court to the judgment of the Supreme Court in Rekha Chaturvedi versus University of Rajasthan, 1993, Supplementary 3 SEC 168. Where which
Para 10
para 10,
at page 175.
where in para 10 it was observed as under A to A. Paragraph. In the present case too, there is no specific rule which governs the situation where by virtue of a corrigendum, the upper age limit for applying for a post may have been enhanced. So, indeed, the revised guideline issued by the SNME department was silent on this aspect. Paragraph. The above dictum of the Supreme Court was reiterated by the Supreme Court subsequently in Rajasthan Public Service Commission versus Kalia Kumar Paliwal, AIR 2007 SC 1746, where it was observed as under B to B, para 21. The situation in the present case is that there are no specified rules as regards the date, relevant date, as regards the relevant date for considering whether the candidate has a requisite qualification. So admittedly, by the last date of filing of the applications, in terms of the corrigendum, that is 28th February 2016, all the three appellants here had already acquired the OTET-2 qualification and were therefore eligible to be considered for engagement as Sikhya Sahayaks. Paragraph. It must be mentioned here that on 8th April 2016, in the present writ appeal, the following interim order was passed. Reproduce that whole order. Paragraph. Subsequently, on 29th September 2022, the following order was passed. Here's that order. Paragraph. Pursuant to the above order, today in court, Mr. Mahapatra Learned Counsel appearing for the SNME department tendered the seal cover containing the results of the participation of the three appellants in the selection process. So those results were perused by the court and also shared with counsel for the appellant as well as counsel for the SNME department. We'll stop. The results show that all three appellants have qualified in the selection test, but were not offered the job only because, according to the SNME department, they should have obtained the requisite OTET-2 qualification as of the original date in the advertisement, that is 30th September 2014, and not subsequent thereto. Paragraph. In view of the settled legal position explained above in the decisions of the Supreme Court, this court is not able to accept the plea of the SNME department that the requisite qualification of OTET-2 was not possessed by these appellants as of the last date for filing of applications in terms of the advertisement read with corrigendum. Stop. Paragraph, even if it were to be the plea that the corrigendum relates back to the original advertisement and the last date as per that advertisement, overlooks the fact that as far as the present appellants are concerned, they became qualified to apply only because of the enhanced relaxation of the upper age limit pursuant to orders of this court, as explained hereinbefore. So it is only by virtue of in other words, it's only by virtue of the corrigendum that the appellants came to apply for the post. Full stop. If indeed the corrigendum were to relate back to the original date, they would not even be qualified to apply. Full stop. Therefore, as far as the three appellants are concerned, it cannot be said that the date for determination of date for determining whether the candidate appellants possess the requisite qualification cannot possibly be the original date of 30th September 2014, but the revised date in terms of the corrigendum paragraph. The second legal position being that in the absence of rules, the last date for submission of application would be the relevant date as far as qualifications are concerned. In the present case, that date would be 28/2/2016. Would stop. Clearly by that date, each of the three appellants had acquired the requisite OTET-2 qualification. Paragraph. For all of the aforementioned reasons, this court does not find, is unable to agree with the learned single judge in as far as the conclusions arrived at in the impugned order. Full stop. It is accordingly hereby set aside. Full stop. The writ appeal is disposed of with a direction to the SNME department to issue appointment letters to the three appellants as SS not later than 2nd January 2023.
Well, the now present difficulty that the SS is not there, that is abolished. Presently, there is no post for Shiksha Sahayak.
What is the equivalent post?
That now the
Junior
contractual teacher and by virtue of that new amendment, they will have to
clarify. Now it is junior teacher contractual. It has now been renamed
Issue letters as
junior teacher contractual.
junior teacher bracket contractual, which is what the SS has been renamed as, within a period of 8 weeks. It is made clear that the date of engagement of the three appellants, which notionally relate back to the date when the original successful candidates had been appointed for the purpose of seniority and other things.
My lord, here there will be subsequent.
They will not get arrears of pay, but all other purposes.
Seniority also, that will create the position, that ordinarily settled position. They have been regularized, their seniority have been prepared. And now your lordships, by virtue of your lordships order, we are going to, we will have to give them appointment. The lordship may not indicate that fact.
All right, within 8 weeks. But stop. The appellants would not be entitled to any arrears of pay. Full stop. The writ appeal is disposed of in the above terms.
Man should kindly indicate that actually I should get the notional benefit. I'm not playing for area due seniority. At least notional benefit, let them indicate as last candidate. Otherwise,
yes, seniority party, if your lordship will clarify the seniority position, then we don't have it.
There is no change. The seniority position.
Because in future, they may.
Whenever that dispute arises, that will get decided. That's better.
Man.
Because those other parties who may be affected are not before us.
What I'm suggesting is, let the seniority not be disturbed of the list prepared only. Let us be indicated as a last candidate.
Let's not say anything, sir. Let's see what they do.
Because what the problem, your lordship, is after 6 years.
Anyway, you'll be at the bottom of that list.
Yes, your lordship. Yes, your lordship.
So
6 years, that contractual, that rule is abolished.
No.
So we don't even know that what happens.
Then 13 rule ta abolished.
Only se task na. Hello, 5 per remove.
I don't know 5.
Clear, Grateful, Your Lordship.
None appears to be dismissed.
6. Item number 6.
Yes, madam. Madam, a interview of the professor was called for in 26 February 2014, the first advertisement. Then again and again, that advertisement modified, altered, and final got its shape in 2017. And the interview held in 2018. Madam. And I am duly qualified regarding the qualification. I am having better qualification, no problem for that. But the only ground of rejection my application is API. API means the economic performance indicator, which normally accepts in a career advancement scheme. About the rejection on the API only based on the journals published in PhD. So now our university UGC has delisted about 4,000 journals. Those who have only created only get to API mark high in this process. So the BHA University, Justice Lakhote also states, given report regarding that, I have annexed that. But the API now, it has all totally replaced in the 2018. When my interview held, at that time, the draft of the correction regarding API has been available, but final gazette come out in 2019. In my regent, I have stated. So when API does not stand, at that time, in the year 2014, there was no place for API. Only the API came when a modified advertisement came in 2015. Prior to that, there was no place for API. And Lord single judge wrongly stated that that it came down on 15/10.
Let's read.
Yes, Miller. Pardon. Yes, but the judgment
Of the single judge, sir, please read the relevant portion of the single judge's order.
Yes, Miller. Relevant portion, the operating person, last page operating person, he has stated my argument and others. Mainly he is basing on my last from para 7, the last 2 page I am going to.
Yes.
7,
Accordingly, before making any appointment, kindly read the first line at internal page 7 of the single judge's order.
Yes, ma'am. Accordingly, before making an appointment, the candidate is to be scrutinized on the basis of essential qualification as provided under UGC Regulation 2010. My advertisement in 2014. Since the advertisements have been issued after 2010, as such, the selection is to be made on the basis of UGC Regulation 2010. But that has been notified also by authority by issuing Annexure 8 dated 2nd to 2018, authorizing candidate to come out with documents and fulfill the required API score. In terms thereof, the petition appeared but has found to be securer of less marks in API than 300, which has been fixed as per the UGC regulation and accordingly has been and not allowed to participate in the interview. Hence, there is no illegality in the decision taken by the selection committee. Well, here I am to say, now should I continue? Will I continue?
Yes, please.
Yes. He submits that the contention raised by the London Council for the petition that the decision taken by the authorities cannot be given retrospective effect, but that is not the case here because the UGC regulation has come in the year 2010, and prior to that, there are another regulation notified in the year 2000, but in suppression of regulations 2000, regulation 2010 has come, containing therein the essential educational qualification and the parameter of the selection of a candidate to a particular faculty member. since the first advertisement has come in the year 2014, as such, there is no doubt about the fact that the selection process is to be made on the basis of essential qualification as provided under UGC Regulation 2010. By following it, the selection committee has screened out the candidature of the petitioner. Hence, there is no illegality. My lord, should continue.
What is your submission therefore, sir?
Yes, ma'am. My submission is that there is no place for API, not even 2000. What about 2010? The API first came in the advertisement in the year 2015 by the Annexure 5 of the writ application. Prior to that, there was no place for API. And my candidate rejected only ground of API, which now already been replaced by the university in the year 2010 itself. I appeared in interview in 2010. When the interview was continuing, by that time, UGC regulation also came. My para 12 of my regender, it is stated that professor only mentioned academic score 75, where I have scored 100 plus 100.225 as per their mark. And ironically, draft for change UGC guidelines circulated in February 2018, when my interview was 2018, while BPUT obvious of performing changes was conducting interview based on old API score. One thing, if API as per, there was no explicit or detailed how you submit your API mark. So all the candidates like me, as per my calculation, my API was 263. But their calculation, it is to be 300. And as per the API calculation guidelines, UGC and AICT are contradicting. How is it contradicting? As per the AICT, it is to be calculated from 1, 2, 3, UGC, 300. But the AICT, it is 300 from 2 and 3. So both are content, not the same. And the same, and the most important thing, since 5-7 years, is the educational institutions are running by contractual teachers. It is a mandatory duty to foster research activities in the university by all these things. By appointing temporary contractual for a long term, it very much hampers the students' study of the students as well as the society. And they are continuing on that.
You are appearing for the opposite side.
Mr. Gata appearing for respondent number 3 in university.
All right.
I'm appearing in the BCM.
He's for AICT.
I am for the UGC. All right.
UGC and AICT.
I am for appearing for AICT members through BCM.
Yes.
So, when my candidature reject only ground of API, which is now not in prior, it was not in the place. Because as per the audit report, by the Annexure 19 of the writ application, it came only March 2014. The audit report I have on it, which says there was no API prior to that. If the audit report says March, how it can give retrospective effect to February? The audit report subdivision says there was no API score on that. The audit report, that the conclusion has been arrived by the Honorable Single Judgment, para 24 of the writ application, I'm reading out, just 2 lines, that the conclusion has been arrived by the Honorable Single Judge on the basis of API implementation since 15/2/2010 is wrong. As because audit report which clearly speaks that the API was not studied in the university till March 2014. API was not implemented in the university till March 2014. And my first advertisement was February 2014. How it can be retrospective?
All right. Yes, Mr. Gata.
May I please, my lord? Your lordship is turn to page para 9, my lord.
Of the impugned order.
Of the writ appeal, my lord.
All right.
Para 9, internal page 7 of the writ appeal.
Yes.
That the respondent number 3, BPUT, again made an advertisement on 19/7/2017 for the post of associate professor to be at
So he applied in 2017.
Yes, my lord. That is the advertisement. And
70 is lacking. But it
By which time API was a requirement.
Yes. And as per the advertisement, your lordship may see the relevant advertisement. That is at page 31. of his writ appeal, my lord. The lordship got it?
31, right? That's it. Yes.
Regular recruitment for Center Advanced Postgraduate Studies, that is for post of professor and associate professor. He has applied from the category of associate professor for civil engineering. Then, my lord, in the bold letter is written, qualification and experience for regular faculty position, AICTE norms shall be applicable for all engineering departments. Then, as per the API, my lord, that your lordship may turn to previous page, that is the same part of the advertisement, page 30. Previous page. Regular faculty recruitment for CET Bhubaneswar, download for advertisement for the post of professor and associate professor. The candidate is required to fill up the API application and send the same along with a separate application summary sheet and API application are required for each applied post. Now, my lord, as for this, he was called to the interview as per the call letter, and your lordship may turn to my counter affidavit, my lord. His application is at page 10. Annex A by 1 series.
Yes.
This is his application. The petition is applicant application, my lord. He has applied for the post of associate professor civil engineering as a writer eligible subject to API score. And then your lordship may turn to API and page 16, my lord. The attendance sheet for the API verification, my lord.
Yes.
Page 16, his name is at serial number 7, my lord. He has attended for the API verification and is as per the API verification next page, that is category 3, my lord, which is relevant. I'll show you from the AICTE guideline and the UGC guideline. Category 3, my lord, your lordship may turn to page 17. He has scored only as per the API score is 100.25. Category 3. The lordship got it?
Page?
Page 17, next page is API marking.
Right. Okay. So he does not make it because of that.
Because of that. And the AICTE guidelines also, UGC, first I'll show your lordship the UGC guideline as well and the AICTE guide. UGC guideline page 31, relevant person. Page 31. Consolidated API score requirement for 300 points from the category 3 of APIs. And the category 3 is given in page 28. What is the category 3? Details of category 3. That is as per the UGC guideline. And so also AICTE guideline at annexure D by 4, page 32. They also have this for category 3 also 300. Same thing. That relevant person, my lord, at page 41. AICTE guidelines start at page 32. Relevant person, page 41, my lord.
Yes.
41 in the table 2 by C, consolidated at the top one, minimum API score, column 3, consolidated API score requirement of 300 points from category 3 of APIs. So admittedly, he has scored 100.25 in the category 3 as per the API verification at the time of interview. So he has not got the more than 300 API requirement.
Right.
And so also the notification also, Orissa Gazette also, E by 5, that's relevant at page 42 also. The requirement is the skill industry department under which they are the administrative department for this university and the engineering colleges.
Right.
Column application, deputy and its constituent colleges where he has applied. Clause 2, these rules shall not apply to teachers, Roman 3, teachers whose qualified norms are below the qualification norm prescribed by the AICTE. So qualification norms is AICTE norm that is here. And then, my lord, he has said that other universities also of the state have not insisted on the API score. That is actually not correct. And the advertisement page 47 has been subsequently corrigendum has been issued, page 49. That's another state university, engineering university, where they have said page 49, in pursuant to the advertisement issued by number VSAT 1813 dated 19/5/18 for recruitment of faculties and officers In addition to the eligibility criteria mentioned in the advertisement, candidates should have the following API academic performance indicator for associate professor, professor, dean, students welfare. So, and associate professor minimum 300 points from category 2 and 3 APIs cumulative. And so also our statute, my lord, the BPUD statute, that is at B/2, page 18. The statutes also require that AICT norm should be there. Page 19, my lord, relevant portion. Serial number 4, Roman 3, my lord. Candidate satisfying eligibility criteria as per the AICTE norm on the last date of application will only be considered for interview. So admittedly, he has not secured more than 300 points in category 3 as per the AICTE UGC norms, and so also the statutory requirement as well as the advertisement also.
My lord, my advertisement, let him complete.
I have given a memo of citation, my lord, where they say the advertisement condition should be strictly followed, my lord.
All right.
And if your lordship permits, may I add one more point for AICT, my lords? Neither the UGC regulations nor the AICT regulations prescribing for API score as a prerequisite for recruitment has been challenged by the petitioner. The validity of the regulations have not been challenged. So the advertisement stipulating for such conditions cannot be termed as illegal in absence of such a challenge to the regulations.
My lord, one thing, UGC guidelines, regulations and the AICT regulations, both the guidelines we are discussing here, they told. Regarding previously I told, both are contradicting. In my para 18 of the writ applicated that candidate submitted API score for category 1, 2, 3, but the BPUD required API score minimum 300 from category 3 only. Whereas, as for AICT, the score to be calculated from category 2 and 300 to be 2 and 3. So they both are contradicting. Regarding API, the AICT and UGC are contradicting. Clearly, I have mentioned in para 18 of my writ application. And second thing, my BPUD, my lord and brother told that the other universities of the state are asking for the API score. In my application, I have stated,
made clear AICTE guidelines will apply, rules will apply. The advertisement itself says AICTE will apply. The advertisement itself says that, sir.
Both the things. However, my lord, I'm coming. My brother said, submitted that one advertisement is another university of the state, Bira Surendra Sai University, the advertisement in their country last page, it is of 2018. But I applied the advertisement in 2014, it altered, modified again till 2017. All the modification I have applied and I attended the interview. So he is quite silent and cleverly silent about the previous advertisement. It is the advertisement 2018, where the draft come to replace the entire, totally replace the API score from the AICT and UGC. And the draft is there. In 2019 Gazette, it has been published. Draft came out in 2018. And another point, if, as they say, if the API score is 300, then why you called us? My API, as per my calculation, there is no explicit information how to calculate the API. I am incumbent, I calculate my API score, it is 263. If it is less than 300, as they say, then it was not necessary to call me, scrutinize my application, and call to me.
Is there any estoppel, sir? Because they scrutinize your application,
yes,
and you don't fulfill the API criteria, they still have to take you.
Yes, they should not call for an interview.
No. You don't have the requisite API score.
Yes.
They have called you for the interview. Are they obliged to still appoint you?
No. I was not, they should not futile,
So,
make a futile exercise.
Suppose they have called you for interview despite you not having the API score.
Yes.
Are they stopped from saying qualified because you do not have the API score? Is that the law?
My
Let's say, sir, minimum pass for a post is, let's say, +2 pass.
Yes.
and you have failed in +2, but you're called for the interview. You say, why did you call for me for the interview?
When I failed, it is not
No,
necessary.
no. So
It is futile
how can
exercise.
that be an argument?
No, sir,
How can that be an
It
argument?
is for
Sir?
the authority. There is a body. I am an individual. They have sufficient machinery. If I am it is open that my mark for API what I calculated personally, not by their direction or not explicit information how to calculate. Mine is 263. Definitely less than the 300. What is necessary calling to me? Number one. Number two, all the universities are conducting the contractual lecture, contractual and temporal lecture, which is a mandatory provision for research activities, which are not doing by the universities and colleges. And regarding other university, like he has stated, in my writ application minor, I have annexed the advertisement from 2014, whereas 15, 16, that issue, what advantage he has annexed in the counter, I have submitted in University Miller. There is no question of API in their advertisement. In the state government, under the state government, both the universities are working, the BPUT as well as BISU. One university I am rejecting for API score, the other university after 2013, 2016, there is no API score. Now he put the advertisement before your Lord, that is of 2018. Not 2014 to 2017. 2014 is the initial advertisement. It again and again and again, 2, 3, 4 more till Annexure 7 of the writ application. It came to 2017 final. And on 2017 also, as for the require, I applied with a separate sheet, which whenever they ask, I apply. Regarding other qualification, I am much qualified. I am not less qualified regarding that. Regarding API discussion, now API is not in the field. Now API is not in the, as for AICT, it has been replaced total. In the year 2018, draft made and 2019 gazette, it has been published. 2019, I have annexed in my regent matter. 2018, February 2008 has been circulated to BPI. Obviously, there are interviews going on at that point of time. Then the gazette come out in 2019. BPUT people know that. And if BPUT is giving so important on API, why other university of the under the state government having the similar situated university not asking for that? In 2015, in 2016, I have also applied. In other university, they have not applied for the AICT. Regarding this, I am reading out AICT. 19 of the para, my writ application, that introduction of API by UGC lacks of clarity in identifying and evaluating journal. UGC has introduced a white list of journals where researchers could publish to meet the API condition. The number of predatory journals were 126 in the year 2013, 507 in the year 2015. Many other universities implemented API in different times and to their convenience. And whatever rules, regulation will be made by the AICT or UGC, a condition there, the state government has to implement in there, not immediately, because they are not funding the state government colleges. The state government to implement as per the local convenience. So where the people got the state government's permission to implement API? They can show any letter, BPUT, that they have accorded permission from the government. But the rule says it should be according to the local conditions of the AICT, UGC makes rules, regulations, but it will be implemented in the state, in colleges or universities as per the local condition, local convenience, and approval of the state government. They have not taken the approval of the state government. One university, BPUT, now I am much qualified, rejected my application as associate professor. University in the year of 2015-16. I am coming, many other API in different times. Then, sadly, predatory journals publishing became a successful business model. These publishing of API basing, the route is, now it became very good publishing model. In this regard, Mr. Lakhotia of Banaras University has expressed his opinion. I have annexed the annexure 14 and 15. But another also. The article of Hindu Leading English Daily on 25th 10, 2015, 12, 2016, 20th April 2017, 5, 9, 2017, 12, 3, 18, etc. Category snobs UGC for growth of predatory journals and paid publication for research articles. So this is the clarity of the API. To grade the API mark is not a like ethical or something qualitative. It depends upon a predatory fake journal mark created. It has been so many complaints come out. That's why the AICTI agency compelled to replace the API totally in the year 2018 draft and the Gazette published in 2019. I faced the interview in 2018 when they might have received the draft in February. In my region term, I have stated that. I will annex that. And in my region also have stated in Odia newspaper, in local newspaper, in leading three like Samaj, Pramay and others. I have said also Indian Express, 16% academic posts in the state university lying vacant. But we are managing with contractual teachers by avoiding what is mandatory for research works not done by contractual and temporary. Second, 11 university, there are 1,033 teachers post vacant in 11 universities of the state. Another also in assembly, that also been discussed. And it's the same in 1,033 professor posts are vacant in the university. Whereas the qualitative people are denied to get any job and to work, and the contractual are being managed with the job. Not now, but since then, more than 7 years. So my only submission, on the ground of API, my rejection, the ground itself is brought from fake and predatory journals. The API mark enhancement, the statement I have annexed, and all of the papers also annexed, about several complaints come regarding to get the API mark, to get the job in API, only predatory journals, fake journals published. Where in market, you will not find a copy of that. Only to get myself better number in API, I put this is my article published in the journal. So this API, after complaints and Justice Lakhotia opinion all over the country, now the UGC and AIC totally replaced the API condition from the university and rules regulations. Now only they have stated where I have stated 100.20, 100.25, 300 minor. Now 100.25, I have ushered as and single judge when pointed out 2015, 2010 state government, that time it was not in utterly in the field. And in advertisement, in modified advertisement 2015, first time university asked for API. Then in 2017.
So now you're repeating us.
My lord.
Orders reserved.
All my orders reserved. I think I am getting.
All right.
One thing, the API mark having less clarity.
Cover things.
Just one interruption.
Call out the next matter.
7.
What is the delay, sir? Kindly examine how many days delay.
Item 7, 8,
28.
10 and 11.
28 days.
Regarding contradicting I tell para 18, I have stated in my writ appeal. And also,
what is the matter about, sir?
Yes.
Item 7.
Item 7, with regard to that Radharani Samar case, the delay is 279 days. I have calculated delay is 279 days.
Sir, you're reading wrongly. What is this?
280 days.
280 days.
280.
But there's a delay of 280 days in filing the present appeal, which has not been properly explained. Consequently, the application for continuation of delay is dismissed. The writ appeal is dismissed.
8, 10 and 11 also, sir.
8,
All.
10 and 11. Same one. 9. Call out 9.
9.
That's item 9. It's a state appeal.
What is the delay?
Unless we haven't taken steps for limitation.
Only 2 days.
2 days. My lads, the question, my lads, here is
the adjective and all we will put. Okay. You just tell us the days.
Unless the question involved is whether with one permit, a particular person can transport forest produce throughout the country. That is, my lords, the question. The factual background here is that a vehicle was carrying timber from a place in West Bengal, and then he had to deliver that in a particular city in Odisha. He stopped at the border by the forest officials only to find that there was no permit that he was carrying for transport in Odisha, my lords. Because, my lords, for that, my lords, there has to be a fresh permit that has to be issued. Now, my lords, may I take my lords to the single judges, the impugned order, my lords. My lords, page 39 is where, my lords, the analysis begins, my lords. Para 5. Considering the rival contentions of the parties, this court finds there is no denial that the seized goods being transported in a vehicle belonging to the petitioner from the West Bengal end, but however, with a timber transit permit up to the border of the state of Odisha. It is only the vehicle reaching the border of Odisha, it was ascertained that the vehicle involved was not having the timber transit to transport the goods inside the state of Odisha. The court here, taking into account the provision at section 56 of the Orissa Forest Act 1972 and the rules 4 and 21 of the Orissa Timber and OFP Transit Rules 1980, finds both the provisions reads under. Section 56. Section 56 deals with seizure of property liable to confiscation. 56(1), may I read? When there is reason to believe that a forest office has been committed in respect of any forest produce, such produce together with all tools, ropes, chains, boats, vehicles, or cattle used in committing any such offense may be seized by any forest officer or police officer. As the relevant clause under which the present respondent has been proceeded is, my lords, will find on the next page, which is 2C, my lords. Because the respondent is the owner of the vehicle. 2C reads, my lords, without prejudice to the...
What happened to the proceedings which were to continue? Just come to the last paragraph.
Yes, my lords. My lords, that is, my lords, my lords, I have to take instructions to what happened with that.
These are not matters where we should...
No, my lords, the question, my lords, is this. That
nothing substantial, sir.
No,
These are all facts. Facts of each case, sir. This won't constitute a precedent or anything like that.
No, my lords,
all this will determine the facts of every case.
No,
this is not some general rule to apply across the board.
No, my lords, the issue is that if the single judge says that under section 56, there is no case made out, then, my lords, under rule 21, which is issue of the foreign transit permit, my lords, how can the person be liable? Because if that person
you don't know what happened. You don't know what has happened in the remaining proceedings. You say you don't have instructions.
My lords,
leave it at that.
My lords, give me a week's time, I'll come back with instructions.
Nothing, sir.
That's because then...
Nothing in these matters. This is all waste of time. You say the challenge in the writ appeal is to an order dated 25th March 2019, passed with a single judge, disposing of writ petition civil 13148 of 2016, filed by the respondent. Full stop. In the writ petition, challenge was placed to the order passed by the District Judge Baleshwar in FAA number 74 of 2015 for a direction to the state authorities to release the seized Ashok Leyland pickup van belonging to the respondent. On the full stop. The said vehicle, paragraph, this above vehicle was seized as it was allegedly transporting timber without having a valid timber transit permit, bracket TT permit, bracket. Full stop. Proceedings. The case was registered on 7th October 2014 for confiscation of the vehicle. Under section 56 of the Odisha Forest Act, is it? What is that?
Please, Minister. Orissa Forest Act.
Which is the year?
That's Orissa Forest Act 1972.
1972. Odisha Forest Act 1972. Paragraph. After the competent authority rejected the claim of the respondent and directed confiscation of both the vehicle and the goods, an appeal was filed by the respondent before the district judge. Full stop. I don't even know if the writ appeal is maintainable because against the appeal of the district judge, the petition is filed, and against that, I don't know. But letter 227. All right. In the meanwhile, proceedings under Rule 21 of the Orissa Timber and Other Forest Produce Transit Rules 1980 rules were also initiated. Paragraph. The learned single judge has come to the conclusion that the goods transported did possess a TT permit issued from the end, West Bengal end, which is where the journey of the vehicle commenced. Full stop. The destination in Odisha was Chintamanipur in Nilgiri. Full stop. What the vehicle lacked was a TT permit for transportation of the materials outside the state of Orissa. Full stop. Paragraph. And after analyzing section 56, the learned single judge has come to the conclusion that the offense thereunder is not attractive as far as the journey of the vehicle in question inside the state of Orissa from West Bengal, originating from West Bengal was concerned. Full stop. However, as far as the respondent not having further TT permit to transport the goods in the territory of Orissa, the learned single judge has allowed the proceedings initiated under Rule 21 of the rules to continue. Full stop. Having heard learned counsel for the appellant, the court is unable to find any error having been committed by the learned single judge in coming to the above conclusions. Full stop. Whether section 56 of the Act would get attracted in a given case will obviously depend on the facts of the particular case. Full stop. The impugned judgment of the learned single judge is indeed peculiar to the facts of the case and obviously constitute a precedent. Full stop. In that view of the matter, the impugned order does not call for interference. The writ appeal is dismissed.
Then 12.
None appears dismissed.
13.
Your Lordship, may I be permitted to submit on behalf of Mr. N.K. Sahu?
Yes, please.
Should the matter has actually become infructuous?
Or counsel of the appellant states that the matter has become infructuous. It is
Your Lordship, kindly one request, please. May it be recorded that the matter is not dismissed, but rather disposed of.
All right. Disposed of as infructuous. All right.
Your Lordship, the Supreme Court order because of which the matter has become infructuous.
That's not necessary. Yes.
14. Add-on 14.
None appears dismissed.
15.
Please, my lord. My lord, this appeal was filed, assailing the judgment dated 20th August 19, passed in WPC number
18,183 of 2008. My lord, the respondent filed the aforesaid rate application challenging the applicability of the ESI Act before this honorable court. And while disposing of the writ petition, honorable single judge, my lord, may kindly see paragraph 14 at page 31, my lord. In view of the, may I read, my lord?
All this one, simply remand. Nothing. What has happened on remand, sir?
My lord, while disposing of the writ application,
What has happened on remand, sir? The learned
lord,
single judge
that
has
was-
remanded the matter.
my lord, that question already has been decided.
What did you do pursuant to the order of the learned single judge?
My lord,
Come to para 14.
my lord.
What did you do pursuant to the direction issued by the learned single judge?
My lord, the appellant challenged that person, my lord, on the ground that the
What did you
direction-
do, sir? You challenged this you filed this writ appeal in 2019.
My lord,
Today we are in 2022.
my lord,
In these 3 years, there is no stay granted of the learned single judge's order.
my lord, we have file memo, but unfortunately,
So you have given yourself a stay.
my lord,
It is okay to do that, sir.
my lord,
If you file an appeal, it is not listed, there is no stay granted. It means you do not have to implement the order of the single judge. That is your understanding.
no, my lord, sorry, that is my fault, my lord.
So
I have
kindly
tried-
implement. You kindly implement. This is only a remand order.
My lord, applicability aspects already decided, and as per the decision of the Honorable Supreme Court, petitioner is required to approve the appropriate forum, my lord, for for adjudication of the.
We could have easily solved this whole problem if you had just complied with the single judge's order. You could have told him in one paragraph or 10 lines that your either act applies to you or does not apply. Instead of filing this appeal, you have just wasted your time, his time, everything. And that's a state corporation only. You could have easily told. By now, all that will be resolved. You've unnecessarily filed this appeal. You say the present appeal by the
My lord,
ESI Corporation is directed
lord,
against a judgment dated 20th August 2019 passed by the single judge, allowing the writ petition filed by the respondent corporation, respondent company, which was a state-owned corporation, with a direction to the present appellate to decide the issue raised in reply filed by the respondent to the show cause notice issued to it by the present appellant, and decide as a preliminary issue the question of applicability of the ESI Act to the respondent corporation. Full stop. By the impugned order, the learned single judge has required the present appellant to pass a reasoned and speaking order, affording an opportunity of hearing, and to decide it as expeditiously possible, open quotation, preferably within a period of 4 months from the date of communication of the judgment. Full stop. Paragraph. More than 3 years have elapsed since the impugned order of the learned single judge. Full stop. Although the present appeal was filed on 19 September 2019, till date, it has not even been listed for hearing. Stop. In the last 2 years, no mention was made of the present appeal for listing. Full stop. It has been listed in its usual turn today. Paragraph. When a specific query was posed to counsel for the appellant, whether the impugned directions of the learned single judge, which have not been stayed till date, have been implemented, he answered in the negative. Paragraph. Considering that all that has been done in the impugned judgment is a mere remand to the appellant to decide the preliminary issue regarding maintainability of the applicability of the EA Act to the respondent, the court sees no prejudice having been caused to the appellant on that score. Full stop. In that view of the matter, the impugned order calls for no interference. The appeal is dismissed.
16. Item number 16.
None appears dismissed.
17. 17.
None appears dismissed.
18.
My lord. This is regarding the evaluation of the answer sheet of the petitioner, my lord. My lord, may kindly see the petitioner has scored. Petitioner scored, my lord, 89%, my lord. Good student, but he has, my lord, what is there, my lord? That I have answered all the questions what I have queried, my lord. Correctly, I have answered. But it was replied that there will be no change, my lord. That is why I came to before this honorable court, my lord, challenging the same, my lord. The lordship may kindly see annexure 11, that is the impugned order of the honorable single judge, my lord. It said, my lord, perusal of the records, it appears that the board has communicated to the petitioner by letter number this, my lord, annexure 10, my lord, stating that after rechecking and re-addition of the marks in respect to answer books on the subject applied for by the petitioner, there is no change of mark. In view of the above, this court is not different, my lord. My lord, there I'll show, your lordship will show I have filed before lordship, my lord. As per the MC, I have, my lord, I have challenged the two my lord, on the MCQ and subjective questions, my lord. On the MCQ, if your lordship will see that I have answered as per the standard book, my lord, and that is also right answer. But say the opposite party say no, that is not the right answer. I have filed the scheme of examination, the scheme of evaluation, my answer sheets, and the answer given by the standard book, my lord. So all are correct, my lord. Maybe for 1 mark, but that was I was not awarded, but I answered that is not the correct answer. But what is there in the scheme of evaluation, my lord, that is correct, my lord. This is 1 point, my lord. As for the subjective questions is concerned, my lord, I have given as to the what is there in the guideline for the standard of evaluation, my lord. on the some questions, my lord, step marking would be there, and they will get this mark, but nothing has been done, my lord. And I have briefed it in my lord in your lordship will see that why I will get that mark. I have brought to the notice of the authority, my lord, but that was not answered. But simply they sticked that there is no change, my lord. This is a question of career of a student, my lord. You would he have got 1% more, you would have got 90%, that you would have got A1 score, my lord. And I have filed all the, my lord, in mathematics also, all answers are correctly, my lord, they correctly deduced everything, my lord, that is there, that I have filed, my lord, but not awarded a proper mark, my lord. That is my sole grievance before this honorable court, but honorable court did not incline to entertain my application on the ground that they have communicated me that this answer is there will be no change. That is why I come before this honorable court, my lord.
Can I ask you a question, sir?
My lord. My lord.
Has this appellant stopped writing exams, or she continues to write exams?
My lord, stopped writing.
She is continuing her studies.
Continuing study. He has gone to other classes, my lord. He has gone, my lord. The matriculation, but he has gone to higher study, my lord. He has gone.
Which higher study?
My lord.
Which higher study?
Plus 3 probably. Yeah.
Plus 2 she must have completed.
Plus 2 completed, plus 3 years.
Then
no doubt he has gone, but this thing I am raised because of this wrong evaluation and the erratic evaluation and casual evaluation. That is why I have placed before.
What difference will it make,
my lord?
No.
And if your lordship will see,
how would it
will it affect her career now?
No, my lord.
For her further studies.
Only, my lord, I will get more mark.
Only marks.
Only mark I will get, my lord.
So there's nothing.
These marks already crossed that.
I have got my lord, A standard, my lord, but I will get A1 standard.
That's all right.
Only for the future purpose, I will get if a percentage will be evaluated for service purpose, I will get more.
The challenge.
But if your lordship will see entire, my lord, I have the MCQ question, was just one question, my lord, MCQ question. My lord, question is, my lord, page 16 that is of course in Odia. That is answer the 46 page, that is the serial number 46, left hand side, right and bottom, my lord. And I had answered is the scored, my lord, scoring is given, my lord. But in standard of examination, that is my lord, the scheme, my lord, it has been given in 18. They are the, my lord, for their regulation, my lord. In 46 there says B, but this will not be B. That is why I filed the standard book in page 19, that the answer which is given in the standard book, the answer. Maybe, my lord, this may be, my lord, for 1 mark, your lordship may take it, otherwise, my lord, you have for 1 mark, and for other subjects there is other mark, my lord. This may not get some benefit, but this shows that the erratic attitude of the authority, that even after by bringing to the notice, they are not doing this. This shows the sorry state affair of the state, my lord. So as far as evaluation is concerned, my lord. Even on mathematics, no one can deduct, my lord. Even mathematics also, though answered correctly, that was deducted. In some cases, my lord, they have answered that other person got more mark, my lord. But this is the situation, my lord. Your lordship, this is up to your lordship to consider this time.
The present writ appeal is directed against an order dated 12 September 2019, passed by the learned single judge, dismissing writ petition civil 16124 of 2019, filed by the present appellant. Full stop. The prayer in the writ petition by the appellant was that the opposite parties had failed to award single quotes appropriate mark in respect of questions both in objective and subjective papers in the high school certificate examination (regular) for the year 2018, held in the month of February 2018. Full stop. paragraph, according to the appellant, should have been given more marks in one objective MCQ part 1 paper
first language
for question number 46 and 4 other answers in the subjective papers. Full stop. Paragraph. Apparently, the appellant did apply for re-evaluation of her answer sheets. Full stop. The reply received from the Board of Secondary Education by the letter dated 15th October 2018. Sorry, by the letter dated 8th August 2018 was that after careful consideration of her request, it had been decided not to enhance any mark in the objective paper, as the scoring key has been verified by the Single Court's Question Analysis Committee, and the committee reported that the scoring key is absolutely correct. Full stop, unquote. As regards the subjective papers, the reply was that there was no change in the marks. Paragraph. The learned single judge has declined to interfere after noting that the board has, open quotation, after rechecking and re-addition of marks in respect of the answer books on the subjects applied for by the petitioner, unquote, communicated that there is no change of mark. Paragraph. During the course of his submissions, counsel for the appellant informed the court that the appellant has since proceeded with further studies and is perhaps now pursuing a graduate degree.
Problem, my lord.
The only difference that would make to the appellant is that if she had succeeded in the writ petition, she might get one more mark, which would place her in the A1, is it?
A1 category.
Instead of the A category. Paragraph. In academic matters,
my lord,
particularly in questions of evaluation and re-evaluation, the scope of interference by the writ court is extremely narrow. Full stop. Unless the procedure adopted is shown to be totally perverse or contrary to the acceptable regulations or rules, there is no question of interfering with the marks awarded particular questions by the examiners. Full stop. In the circumstances of the case as explained, as noticed herein before, the court is not satisfied that any error has been committed by the learned single judge in declining the reliefs prayed for by the present appellant. Full stop. With there being no grounds made out for interference, the appeal is dismissed.
If my lord, there is 1 mark, 7 mark, your lordship kindly. If you get 7 mark, my lord, that will be A1 score, my lord. Your lordship said 1 mark, my lord, in MCQ question. If you get 7 mark,
kindly call out.
19.
But this present case is squarely covered by the judgment of this honorable court passed by a single judge. I have already given a copy of this order, my lord. What happened in this case?
Kindly keep it here, sir.
Fact of the case is that the petitioner is a Sikhya Sahayaka. In 2011, after completion of 3 years, he has been junior teacher as per the guidelines. But due to the illegal in criminal case, and subsequently he has been acquitted from that criminal case, which is also annexed in that acquittal order in my writ petition. But without considering the authority has been passed an order that due to the criminal cases, he has been allowed to join in my duty. And subsequently, the single judge has passed order under Annex 2, case 2026, not reflected, taken into consideration also that acquittal order, which is also annexed in the But this number of cases has been passed by this honorable court, which I have also, my lord.
So the facts are not clear, sir. When was the criminal case commenced? What happened? When was the
My
date
lord,
of your acquittal?
My lord, 2015, my lord. 2011, the petitioner was appointed as Sikha Sayak.
Sir, these years don't have dates, is it?
My lord, sorry, my lord. 10/4/2000.
You don't prepare any, when you have to finally argue a matter, you don't prepare any list of dates, sir?
Tomorrow. I will.
No. Tell us. When I was a lawyer, I could never go and argue before a high court without a proper list of dates.
Sorry. That's
Maybe it was my bad habits, but those bad habits have stuck hard. No need for a notice, sir. Every lawyer should do it. And that way we start blaming ourselves.
Forward, then I will get that chat. I will be.
It's all right, sir. We will do that extra work. No worry. We have a lot of time. Tell us.
So 10/4/2011, the petitioner was appointed as a Sikha Sayak.
All right.
As per the guidelines, he was after completion of 3 years. In 10/4/2014, he has been to junior teacher already.
All right.
And but in my lord, in 2015. 15, he has been 13/11/2015. My lord. He has been a FIR has been lodged against the petitioner, and on that basis, he has been in custody. And subsequently, he has been acquitted. Acquitted order I have also annexed, my lord, on 31/1/2017, my lord.
That was only subsequent, sir.
My lord? 31/1/2017, he has been acquitted. But
So on the date when they disengaged you,
my lord,
you were still facing a criminal case, correct?
My lord, they have been issued in so cause while I am joining. They have been after bail. I filed an application for the allowed to participate, join in my duty, but they did not allow due to the pending of these criminal cases. So subsequently, my page 20, my lord, I have give my joining report after acquittal. They did not accept issue an order of so cause. Page 19 on dated 10/5/2017. Okay.
No, the question was your unauthorized absence, sir.
No, my lord,
what you've missed out a very important fact is that
what they are stating that the unauthorized absent due to the criminal case, they are not allowing me to perform my duty. This
Did
is
you
the
write
thing.
a letter? The point is that if you simply went absent, that's one thing. If you wrote to them saying, I am now in custody and therefore I'm unable to attend duties, that's another thing. When did you write to them, sir? You go absent from duty without intimation or with intimation? That's a short question.
With intimation, but that intimation.
Where is that intimation, sir? Where have you mentioned in your writ petition that you gave such an intimation?
Because they have been mentioned in their disengagement order under Annex 5 before this writ petition that he has been unauthorized absent and is a 30-day so cause notice for disengagement was issued to Sri Mukhi for such lapses by this office order dated 10 as per the government guideline, my lord. But they did not allow me only due to that the same.
So where is your written request that I want to report for duty? Where is that letter?
So that letter not along with the petitioner, but the fact is that
no, that can't be a fact then. This fact is only known to your mind. How do you establish a fact if you do not produce a contemporary document to show that you are actually wanting to join duty and they did not take you on duty? Did you inform them? Did you inform them, sir, I'm involved in a criminal case, therefore I'm not able to come for duty? Did you inform.
Due to that, they are not allowing me to join my duty for the after.
Anyway, I think this kind of thing will not take us anywhere. My question to you is, did you inform them? What is your answer to that?
That part I will be taking instruction.
No.
Because the single judge, while passing that order, the order acquittal which has not been taken into consideration.
Where's the question of acquittal? First of all, it's your conduct. You stay away from duty, sir. Acquittal comes later. Acquittal is in 2018.
2017.
Your absence was in 2015.
15.
What is the document you wrote to the state authority? Where were you working, Sikya Sahayak? When did you write to the project director that I'm going to be absent or I have been absent? Where is your letter?
I was in custody.
So that's the whole problem, sir. So you stay away without intimation.
I've also intimated what that has.
Where is that intimation? Where is that letter? I'm repeatedly asking you, where is that letter?
That's why that letter, when it has been communicated.
You have to first plead it, sir. Just let's understand. In your writ petition, you should say, sir, I wrote a letter on such date to the authority saying this is why I'm absent. I wrote a letter saying, please allow me to join duty. Then when they refuse, you have to write another letter saying, I reported for duty on such and such a date. You did not allow me to join duty. This is how it has happened. I mean, this is how you should, first of all, you should plead all this in your writ petition. Not that suddenly you will produce these letters from somewhere. Have you pleaded this in your writ petition?
In my writ petition, kindly peruse the page.
In this High Court, first of all, when I ask a question, lawyers usually don't understand. So I have to every time trouble Justice Raman to again put the same question. And then when I ask a question, the lawyer will ask me a question. He will not answer my question, but he will ask me a question.
In page 20, after my acquittal, I have been given my joining report. They are not forwarded to the authority, higher authority, which has been.
All right. The challenge in the present appeal is to an order dated 9th October 2008. 17th September 2019, passed single judge, dismissing writ petition civil. Disposing of writ petition civil 16788 of 2019 filed by the present appellant. Paragraph. By the said writ petition, the appellant had sought the quashing of an order dated 9th October 2018, passed by the collector cum CEO Zilla Parishad Kandamal, disengaging the appellant from the post of junior teacher (contractual) close / Sikya Sahayak with effect from 1st April 2016. Paragraph. The background facts are that the appellant was engaged as Sikya Sahayak for a period of 1 year by virtue of an agreement dated 27th March 2011 between him and the CEO Zilla Parishad Kandamal of respond number 3 for a period of 1 year and posted to the Kapadi PS of Firingia block in Pulwani. Full stop. While the appellant was working as such, ST case number 59 of 2016 was initiated against him and others arising out of Khajuri Pada PS case number 118 dated 20th November 2015, resulting in a GR case number 767 of 2015 in the court of the SDJM, Pulwani. Paragraph. As a result of his involvement in the above criminal case, the appellant was absent from duty since 22nd November 2015. Full stop. Apparently, he never informed the authorities of the above development and finally reported for duty only as a result of his subsequent acquittal by the Additional Sessions Judge Pulbani by the order dated 30th January 2017. Full stop. According to the appellant, when, after the above acquittal, he reported for duty, the authorities did not permit him to join. Full stop. Instead, a show cause notice was issued to him on 10th May 2017 for disengagement. Full stop. The impugned order dated 9/10/2018 shows that the appellant was unauthorizedly absent from duty since December 2015. Full stop. His one-year contract came to an end and was not renewed for the subsequent years. Full stop. The reason for his disengagement was, in fact, the non-renewal of the contract for 2016 and 2017. Full stop. Paragraph. It is seen from the impugned order of the learned single judge that since renewal of contract was subject to satisfactory performance and the performance of the appellant indicated that he was involved in a criminal case, open quotation, the same has not been taken into consideration, unquote. Paragraph. The crux of the matter is the unauthorized absence of the appellant from duties since December 2015. Full stop. It appears that no attempt was made by the appellant to ever inform the authorities why he was absent. Full stop. There appears to be no document also produced to show that the appellant sought to join duty and refused permission to do so. Full stop. The appellant was obviously aware that his contractual appointment, which was on a yearly basis, required to be renewed year after year. Full stop. He appears to have made no attempt in that direction either. Paragraph. In the given facts, therefore, the impugned order of the authorities dated 9th October 2018 disengaging him from the contractual appointment cannot be faulted. Full stop. This is irrespective of the fact that the appellant may have been subsequently acquitted in the criminal case. Consequently, the court finds no reason to interfere. The appeal is dismissed.
20 mailer, no instruction.
Disposed of, no instructions disposed of.
21,
none appears dismissed.
22,
none appears dismissed.
23,
Your Lordship, may I please, Your Lordship? Your Lordship, I'm sorry, Your Lordship. Yesterday, I could not submit Your Lordship's judgment. So, press the trade discount, Your Lordship, but my Lord Justice Raman has given. This is Your Lordship has passed the order against the revenue.
And if the order dated 6 July 2022 passed by this court in STREV 25/2013, bracket Messrs. Sun Pharmaceutical Industries Limited versus State of Orissa.
Also, that judgment in case of C8 also has been, Your Lordship has recognized that judgment. C8.
Correct. The questions urged in the present revision petition already stand answered against the revenue. Consequently, the revision petition is dismissed.
Your
Lordship, item number 24. Your Lordship, I may be permitted to take Your Lordship's attention to the tribunal's order. This is in Dalco, Your Lordship. which is pending before Honorable Supreme Court, Your Lordship, in SLP number 38103 and 38104 2013, Your Lordship. Pursuant to the High Court order, the London Tribunal has passed this order. Your Lordship, now this is before Honorable Supreme Court. So far as the coal ITC input tax credit coal, Your Lordship.
Correct. You say the Mr. Mishra, Learned Counsel, Standing Counsel for the State, informs the court that the questions urged in the present revision petition will have to await the judgment of the Supreme Court in other matters where a similar question has been raised concerning the use of coal in the manufacturing process to generate steam. Being treated as an input for the purposes of section 2(25) of the Orissa Value Added Tax Act 2004. Paragraph, the petition is adjourned sine die with permission to the petitioner to mention it for listing after disposal of the above matters by the Supreme Court.
Your
Lordship, item number 25. Your Lordship, may kindly turn to page 10, the question of law, Your Lordship.
Yes.
Whether in the facts and circumstances the tribunal is perverse and its aid, in as much as it failed to appreciate that there are two sales involved, one by HPC limited to the contractor opposite party, and the other by the contractor opposite party registered under Odisha Sales Tax Act to contracting, and thereby the revenue is justified in levying sales on the latter intrastate transaction, Your Lordship. Your Lordship, and also the second, Your Lordship, also on its purchase from HPC Visakhapatnam, Andhra Pradesh, used in the course of execution of contract was contract roadwork, whereas the contractor registered dealer under Odisha Sales Tax Act transfer property in the said goods to the contractor in the state of Odisha. Now, Your Lordship, may kindly turn to the tribunal's order, page 27. Paragraph 9, Your Lordship. It's also notice has not been issued in this case. So far as the only thought issue, so far as the purchase of bitumen, Your Lordship. That purchase is interstate purchase and Your Lordship, but used in the bus within the state of Odisha. Your Lordship, paragraph 9, Your Lordship, tribunal's order.
Yes.
At page 27.
Yes.
As regards to so far as the deduction, Your Lordship, this is not, but so far as, Your Lordship, 6 to 7 lines below. But so far as the deduction towards the purchase of bitumen to the tune of rupees 74 lakhs, so and so is concerned, he has assigned the reason that it has been purchased from HPC Visakhapatnam, the state of Andhra Pradesh, and has not suffered Odisha sales tax. And the same is not to be deducted from the turnover, Your Lordship. And but the London Tribunal has allowed this, Your Lordship.
That deduction also.
Deduction also. Your Lordship, so far as this deduction is not to be allowed. Your Lordship, so far as the other, Your Lordship, it has been accepted by the government, but only on this issue. Lordship, the tribunal.
No, but they've clarified. Just see the bottom of para 10, last 3 lines.
Your Lordship.
Of course, before allowing deduction, it has to be examined the tax has already been paid or not.
Your Lordship, so far as this is CST, so far as the levy of OST, Your Lordship, Odisha Sales Tax Act, it has to be paid on that use of bitumen, Your Lordship.
No, but the tribunal has clarified it has to be examined whether it has already been paid or not.
Your Lordship, the dealer has to produce the required document and SST allowed deduction, so and so, Your Lordship, since the dealer is entitled to, Your Lordship, since the dealer is entitled for deduction of the value of goods purchased in interstate sale and utilized in those, so the order SST refusing to allow
That's
deduction.
Correct, only. If he has already paid tax as an interstate sale, why should that not be allowed as a deduction? Correct. Where is the second sale? That's the question of second sale. There's no finding that there's any second sale. Yeah, anyway, you have to confirm that whether tax has been paid or not. This is not going to cause any prejudice to you, sir. Counsel for the state presses the revision petition only insofar as the allowing of deduction, CST. No, allowing of by the tribunal of deduction of rupees 74,71,408 towards purchase of bitumen which, according to the respondent SSC, was purchased from a entity in Andhra Pradesh by way of interstate sale. Stop. The tribunal noted that the goods purchased had been utilized in the works contract performed within the state, and therefore non-allowing of deduction was not correct. Paragraph. This is obviously purely turned on facts. To stop, the tribunal has been careful to clarify that, open quotation. Of course, before allowing deduction, it has to be examined whether tax has already been paid or not on purchase of bitumen to the tune of rupees 74,71,408.00, unquote. In that view of the matter, the court is of the view that the above observation of the tribunal in the impugned order dated 9/1/2017 does not give rise to any substantial question of law that requires to be examined in the present reference. The petition is accordingly dismissed. In the present, not reference, revision petition, the STRV is accordingly dismissed.
26.
Let's see, item number 26 is covered here. Let's see. Let's see that chokered. Here, let's see, chokered as cattle feed in the
In view of the judgment of this court dated 2nd August 2022 in STREV number 31 of 2011, State of Odisha versus Messrs. Hitachi Industries. The questions urged by the state in the present revision petition stand answered against it. Stop. Consequently, the STREV is dismissed.
27.
Let's see, if item number 27 is covered by your Lordship's judgment that Chandrakanti Jayantilal so press the levy and penalty under section 42(5).
So notice has to go.
Your Lordship, the amount here
is insignificant.
37,960.
In view of the insignificant amount. The court is not inclined to interfere. However, the question of law is left open for decision in some other appropriate case. The STRV is accordingly dismissed.
Your Lordship can say, even though it is come.
That's not, all right.
28.
May I please be notes? Questions of law is at page 12 of your lordship's brief minutes. May I just please it minutes?
Yes.
Whether on the facts and in the circumstances of the case, the petitioner is entitled to avail input tax credit on purchase. 2. Whether on the facts and in the circumstances of the case, denying of input tax credit by giving less credit of tax payment is in accordance to law and in consonance with the aims and objections of the statute's objects. It should be objects of the statute. Then, my lords, the third question is be relevant in spite of the fact that your lordships have already decided, my lords, that is whether penalty is to be levied, my lords. And the fourth question, my lords, which I beseech your lordships to kindly refer, is whether on the facts and in the circumstances of the case, the tribunal has committed illegality in not following the ratio of the judgment rendered by this honorable court, so far as this AVR is concerned, whether they can go beyond the AVR or not. So those are the 4 questions, my lord. The facts are, my lord, this particular petitioner is a pharmaceutical trader, my lord, in pharmaceutical products, my lords. At the relevant point of time, if your lordship would, I have just given the copies of the returns, my lords.
What is the tax amount, sir?
The tax amount, my lord, is 1 lakh amount. Return rate, here, my lord, at the relevant point of time, the form of return which was applicable with effect from April 2013.
No, so you want to press this?
Sorry,
you want to press this revision petition?
I, with great respect, yes, my lords. Because the penalty, my lord, what has happened, my lord, at that particular point of time, input tax credit was being allowed by the system itself.
Okay.
And that's how I availed my input tax credit on purchases of goods and charging 5% tax on the MRP price, my lords.
Subsequent notice returnable 5th April. All right. He accepts notice. All right.
Questions of law, my lord?
We'll see. Let notice.
29.
That's 29, my lords. The questions of law, my lord, is at page 10 of your lordship's brief, my lords.
And this is it.
Limitation petition is there in that.
I'm so sorry, my lord.
No,
I
just only find a stay. Was there?
I'm so sorry, my lord. There's a limit.
No, only original certified copy, and there's no
limitation. I think the defects have been already removed. May I just place the other? That's at page 10, my lord. It's your lordship's brief notes.
Yes.
Lord, question number 1, my lord, is whether on the facts and in the circumstance of the case, the learned Orissa Sales Tax Tribunal is correct to opine that there was a suppression of sales to the tune of 4 lakhs.
So this is similar to that already decided, I think. There has to be an inquiry and all that.
Or here, what?
No.
Lord, here, there's a. No, there was, if the premises of the petitioner was inspected, my lord, certain incriminating materials according to the revenue was found out, my lords. Here, my lord, so far as the first...
no, the suppression of sales, we've said in some judgment that it can't be on conjectures and surmises. There has to be...
My lords, that is, my lord, that is the reason why the tribunal, in the major part of it was dropped, my lords. So your lordship may kindly turn to page 22 of the tribunal's order, my lord. So
no,
far,
your notice is not gone. So,
no,
concrete findings are there. Your lordship suppression is, and these are the question of fact. Your lordship and clearly categorically is decided by the learned tribunal. Only question of fact. There is no question of law in this case. Your lordship.
No, there's no positive finding, lord, regarding sales suppression, lord. They just go by whatever has been given in the report, and they say that this amount of tax has been suppressed.
Your lordship, tribunal and the tribunal page 39. Your lordship may kindly turn to page 39 and 40.
Exactly. It's a notice written till 10th April. All right. He accepts notice. That's right. Most of this because of that.
Sorry.
No, there's a penalty amount. That's what's driving all of you to press. That's right.
30,
Nana, please discuss.
31,
Your Lordship, item number 31, that is the matter, Your Lordship, what the validity of the provision of section 2J, Your Lordship. All the cases have been listed on 5th December, Your Lordship.
5th of December. All right, list on 5th December. All right.
32,
May I please, Your Lordship? My Lord, in item 32, the representation under Annex 3 is pending before opposite party regarding eviction of unauthorized occupation from the government land, my Lord.
That is to be disposed of.
My Lord.
Have you named the persons? Have you named the unauthorized occupants, sir?
My Lord.
Unauthorized occupant's name.
Yeah,
have you
he's
stated?
put it there.
It's there.
The petitioner's representation, bracket Annex 3, shall be examined by Tahsildar Champua, and after notice to the petitioner and opposite parties 4 to 26, and after giving them a hearing, the reasoned order shall be passed not later than 10th April 2023 and communicated to the parties within a week thereafter. The court clarifies it is not expressed in the
Next item is also same.
33,
Unauthorized and
As this. Same here, the Tahsildar is Bhadrak.
Tahsildar Bhadrak.
All right. The petitioner's representation, bracket Annex 2, shall be examined by the Tahsildar Bhadrak, and after notice to the petitioners as well as opposite parties 4 and 5, and after giving them a hearing, a reasoned order shall be passed not later than 10th April and communicated to the parties within a week thereafter. The court clarifies it is not expressed in the matter.
Next is also same.
34,
Only Balyapur.
Tahsildar Balyapur, page 14 is pending before Tahsildar. Now is not allowed to use that land on the OP number 5.
The petitioner's representations, bracket Annex 2, shall be examined by the Tahsildar Balyapur, and after notice to the petitioners and opposite parties 6.
I mentioned a 6, but it is
5, yeah. And after giving them a hearing, a reasoned order shall be passed not later than 10th April. Shall be communicated to the parties within a week thereafter.
I filed a miscase.
The court clarifies it is not expressed in the matter.
I filed a miscase. Now is stacking materials for construction over the Gochar land.
We open to the petitioners to pray for appropriate interim orders from the Tahsildar.
35,
May it please, Your Lordship. This matter is about Telugu students.
Have you produced the proof of dispatch of
in Gajapati district are not provided with the books in their mother.
Sir, are you able to hear the question? Just asking the question.
What is,
Last
what
time,
is
Your
the,
Lordship,
the dispatch proof? Proof of dispatch.
Yes, I have brought it. Earlier, they had sent through a registered post, but they had not kept the receipt. Again,
This is has a date of 28/6/2022.
that is addressed to the
28/6.
Commissioner from Secretary, School, Mass and Education.
We don't even know if it's the same thing. Just make a fresh representation, sir. Permitting the petitioner to make a fresh representation in accordance with law to the authorities. And after following up on such representation to seek appropriate remedies in accordance with law, the petitioner
Millards, stay.
just give it back.
Already number from Millard from 2015, we have been filing, we have been submitting number of petitions.
That's the problem is, sir, if you don't reach them, just tell them. If it doesn't reach them, there's no
If it
point.
doesn't reach them, they have no opportunity to decide or take up your.
I have already, I have already submitted by registered post. Earlier they had submitted. Thereafter, they have not kept the receipt. Then again, I told them, you submit it through registered post. They submitted.
5th December?
Slightly more.
12th December.
12 December.
Yes. At the
36
request
and
of Mr. Karar, list on 12th.
36 and 37.
37, yeah. Okay.
Greatly obliged.
38.
May I please your lordship? The petitioner challenges the order under Annexure 1 regarding the attachment of the bank account of the petitioner under section 79(1)(c) of the OGST Act and rules, my lord. Well, the petitioner had filed the appeal also against the final demand order. The appeal is pending. While the appeal is pending, the opposite party had forcibly attached such order, which is illegal and also against the provisions of the law. 100 section 7.
Your lordship, in this case, copy has not been served to us.
Yes, copy served.
No. You might have served to the government, not to the GST department.
Date has been served by the department.
You have to serve the departments. They are the main people.
Well, in this case, I am facing a lot of trouble. My bank
So
account.
the sooner you serve, the better, sir. Then we can hear it. Let him take instructions. You say notice, Mr. Mishra accepts notice. And on behalf of
Well, now I am serving my
parties,
copy, my lord.
2, 3.
Well, now I am serving my lord.
Yeah.
But I'm in
I
past my lord.
Ishwar Mohanty accepts on behalf of opposite party number 1. Notice to 5. Now, Axis Bank, you have to serve, sir.
Axis Bank, my lord.
You have to serve them now.
Axis Bank usually. But
Yeah.
Well, interim application may be allowed, my lord. Bank account may be released, my lord.
That's the final relief, sir.
No,
That's
no,
not interim
Act
relief.
says that. So 100
That's the final relief in the petition.
My lord, yeah, 107 says that the stay is
Sir,
automatic, my lord.
Who's against you? Who's against you?
Against my lord GST.
So unless we hear them, we cannot allow your writ petition.
No, only one provision I am mentioning.
You can mention it today, but we will not allow it till we hear them. Till they reply.
It is
till
so
he is
much
able to get instructions and till he replies, we will not allow this. We'll read all the provisions you ask us to read, no problem. But relief we cannot grant till we hear both parties.
Only one thing, my lord. I just mentioned, my lord. The provision says, if I shall deposit the 10% of the demand amount, then the stay is automatic, my lord. Section 107, para 7. Then, my lord, the miscase may kindly be allowed, my lord.
See, allowing miscase means allowing your writ petition. So for which he has to take instructions.
Well, in the court, my lord, I am serving the copy, my lord.
So notice to opposite party number 5, Dasti in addition. So this is on 7th December, sir. 7th December.
Your lordship,
So you are not free.
6, 7th, 8. 6, 7th, 8, I will not be here. So next week,
you can make other arrangement. It is certain. You can make other arrangement. You have other panel lawyer.
Your lordship, please.
We'll have it on 7th. We'll have it on 7th. 7th December.
39.
Item 39 on behalf of Mr. Ratha. I seek adjournment.
This is a matter sent by the Supreme Court back, and we are supposed to expeditiously dispose it of.
Your old matter, my lord, was a transfer case, my lord.
Whatever, sir. Supreme Court has asked us to dispose it of expeditiously.
I agree.
It's a 20-year-old matter.
With your lordship's
20-year-old matter, sir.
But some documents are yet to be
contributed. Whom are you? You are for the petitioner.
No, on behalf. Yes, my lord. I am seeking adjournment on behalf of Mr. Ratha, my lord.
Where is your paper book? Where is your paper book, sir?
Yes.
What is the matter about? Why should we adjourn it? What are the documents you want to file?
The case, the transfer case, my lord, transfer beef. So some documents are
internally. You may transfer from many council to many council. You have to tell us what the issues.
Earlier, my lord, the challenged before this honorable court, and this honorable court was pleased to
dismissed the case, and thereafter SLP was filed before the Honorable Appeals Court. And the Honorable Appeals Court was.
When I ask you what is the issue, you have to answer that question. All right, not that you filed SLP, the case got dismissed
The
here.
Honorable Appeals Court has directed to.
You still do not know what the issue is, sir.
Yes, I know. The issue relates to question number B, D, and E. It relates to whether the learned tribunal is justified in not deleting the tax-free and fast-point tax-paid goods turnover from the taxable turnover, and whether the learned tribunal is justified in holding that the receipts of higher charges recovered from contractors by appellant falls within the ambit of deemed sales as contemplated under section 2G IV of the OST Act, whether the receipts of higher charges of machineries from inter-department of the assessee for accounts purpose is sale to self as contemplated under section 2G IV of the OST Act. Three issues have to be decided here, my lord, in view of the Honorable Appeals Court's directions. Some documents are yet to be collected.
What documents?
Because the petitioner company has not supplied the relevant documents.
What is the relevant documents, sir? Tell us. What are the relevant documents?
The details of the assessment records are the lower courts file.
Lower courts file?
Lower records finance. What is the amount of first point tax and
all that is there here, sir. In your paper book, it's all there. You want to tell us page of your paper book? We can tell you. It's there in your paper.
Right, but
don't take it so casual. See, the question is the whole attitude is very casual. You can just walk into a high court, say, I want time, you'll get time.
I'm seeking
very casual
adjournment on behalf of Mr. Ratha.
Sir, this is far more serious because it has been sent back with the Supreme Court. It has a specific direction. It should be disposed of early.
I seek only a short adjournment. Only 1 week time may be given.
What are you aware of the issue, Mr. Mishra?
Your Lordship. Your Lordship, the details before Lord Tribunal has passed the detailed order, and this Honorable Court, while disposing of the matter, has cognized the order of the forum below. Your Lordship, the Lord Tribunal's finding, everywhere the finding have been accepted by this Honorable Court, and this Honorable Court has categorically held that paragraph 11, 12, 13. Your Lordship, that the Lord Tribunal has passed the order and a very reasonable order, reasoned order, Your Lordship, this Honorable, this.
No, but that's been set aside. No point in referring to that.
Your Lordship. And Your Lordship, Tribunal's order.
The first question is whether first point tax and tax suffered goods have to be deleted or given deduction.
Your Lordship.
You have to take those findings.
Your Lordship. Lordship can.
Yeah, paper books are also there, correct. So it can't be part of the taxable turnover. I think, yeah. That's not a civil.
Your Lordship, Your Lordship, may kindly turn to page 64.
This is the Reliance Dredging Corporation.
Class 3.
Your Lordship,
Class 3. That is 64. Page 64.
page 64.
Tribunal's order.
Your Lordship,
1, 2, 3. 1 does not arise.
Your
2
Lordship,
2 does not arise.
Your Lordship.
Canteen and scrap. That doesn't.
No, only B, D, and E.
Only 3.
Your Lordship, B, D, and E.
Yeah, it's confined to only those.
Your Lordship, so far as
3,
so
4.
Only B, D, and E, sir.
B, D, and E. So far as the ground number B, Your Lordship, so far as the question of law number B, Your Lordship, whether the Lawrence tribunal is justified in not deleting the tax-free and first point tax-paid good turnover from the taxable turnover as such the order is illegal and admitted. Your Lordship may kindly turn to page 64. This question, this issue was not before the Lawrence Sales Tax Tribunal. This, so far as the tax-paid goods or first point tax-paid goods adjustment, that is not in the ground before the Sales Tax Tribunal. This is a press ground. For this reason, this Honorable High Court, while dealing in the first round, has stated that this is a press ground. So this ground cannot be entertained, Your Lordship, because this ground was never before the fora below.
No, but was it not before the first appellate authority and assessing officer?
Your Lordship, he has not taken the ground, Your Lordship. I'm sorry.
In some other form. You take 64, bit 3. That is what levy of tax on supply by the
Stores
company of stores materials like cement and steel to contractors engaged for modernization work on recovery of cost.
That is cost recovery.
As sales.
Cost recovery. That is a separate material. Cost recovery. This is not tax-free and first point tax-paid goods, Your Lordship. Cost recovery and first point and tax-free, something different, Your Lordship. So cost recovery means, Your Lordship knows that is cost is to be recovered from by the contractor. So Your Lordship, here this
does it at least emanate from the assessment order?
Your Lordship,
see, it has to come from somewhere, right? They can't suddenly.
Can it be tomorrow? Lordship, I'm sorry, Your Lordship. Or your Passover, Your Lordship, I can.
Yeah, but this is not the same as first point paid. This different from but that's different first point paid goods. No, but we have to answer the question which the Supreme Court has framed. So there are 3 questions we have to answer those questions. See, let's see the other assessment order.
Cost recovery material is there. First appeal order also at page 42.
No, and even page 26, the assessment order also discusses
Your
that.
Lordship. Cost recovery materials is there, but so far as the tax free and Your Lordship.
So I don't know where they got this first point paid, tax paid goods. First appeal, let's see.
Page 42 appeal order, his argument is about cost recovery material. First appeal, page 42.
That's what the cost recovery.
Page 43 and 44. Okay. That's cement and steel. Let's say page 43 and 44. I think appeal order. Page 44.
44.
Page 44. In the first paragraph, you'll see page 43, the last paragraph. Paragraph 6 of page 42. It has started in the first appeal order, and the details are there. The materials are ensured by the appellant and the contractors bound to return to leftover materials after completion of work. However, since due tax has been paid on purchase of cement, bricks, and further levy of tax on such materials stand unjustified. In order to fortify his views, stand to the effect that non-levy of tax on the value of the material issued to the contractor on cost recovery basis for exclusive utilization thereof in his own work. The appellant has furnished a copy of the document pertaining to special condition of the contract, which inter alia stipulates in clause 4.1. All the material to the contractor shall be removed from the worksite and shall be your lordship. And on careful consideration of the fact and discussion of the case, their proper perspective, I am of the opinion that the contention is taken by the appellant is no assistance to him by way of tilting the balance in favor in force.
So I think this is the same first point of sale. See, just come to page 44.
And in the next para.
In the circumstances.
Detail above the extra demand raised on the point for all the impugneers are held to be unsustainable. Further, in absence of corroborative evidence to the effect of payment of tax at the sale, of the cement, etc., on payment of tax at the concessional rate of agitated by the appellant, the action of the learned assessing officer levying tax thereon stands still.
So because no evidence was produced about payment of tax on the first point of sale,
Your Lordship.
They've included it in the taxable turnover.
Your Lordship.
So they must show that they have already paid tax. But they were unable to show that. And where does the tribunal deal with this?
Tribunal chief. Your Lordship, at page 76, running page 76.
So that is the cost recovery basis.
Your Lordship, only cost recovery basis.
Will constitute sale to be exigible. So that's a different point.
Your Lordship. Your Lordship, also, second appeal before there is no ground for arbitration, that has not been decided. Only cost recovery ground was there, so cost recovery has been decided by the tribunal. Page 79, Your Lordship, can page 79. 8 to 10 lines below, it is further to be noticed that the contractor shall not be entitled to return any such material unless the required by the employee. In such a case, contractor gets required to utilize the same material in the manner he likes. The cost of material supplied to the contractor by employer recover. Here, let's see, only cost recovery so far as. And judgment also, NM Goel judgment has been considered at page 80. Only cost recovery, Your Lordship.
May I submit one thing, madam?
The copy which is received here is only on 17th. The questions that are being demanded to support for a paid position by the Supreme Court. The demanded by the Supreme Court of India to support for a paid position are D, B, and E. Council appealing the petitioner states that transferred brief and seek more time for it to collect the necessary papers and reports to make submissions. Council of the state also seeks some time to examine the matter. There is a specific direction Supreme Court of India that the acquisitions which pertain to the year 2001 should be expeditiously disposed of. Accordingly, the court directs that both parties will file their respective notes and submissions. Possibly facilitate early disposal of sensitive financial pressures.
Second, third, or fourth electrical. 1 second.
3rd January. All right.
40. I'm permitted 1 week time to remove the defects.
Then matters, sir. What is it about? What's the tax effect here?
And the total tax effect is 4.21 lakhs. It's coming under the monetary limit.
Then
But the question, if your lordship will see the question of law.
No, so it's above the monetary limit.
No, it's not about the monetary.
Then we'll dispose it of, leaving questions open. Since the tax effect is below the limit, leaving the questions of law open, the appeal is disposed of.
41.
None appeals dismissed.
42. 42, 43 and 44 million. If you see the impugned order, there is a noting that the original impugned order has not been filed. But if your lordship will see the impugned order, there's a batch of cases has been preferred from 10, 11 to 20 of 2010. All these appeals have been pending. I could not able to lay my hands on which appeal the original order has been filed.
But what is the question involved?
Yes.
Let's see what the question is. You examined the tax effect here.
My lord, question of law is at page 11. Tax effect in the first case, it is 34 lakhs. It is above the.
What's the monetary limit? 25 lakhs.
It is, no, under the customs, it is 15 lakhs.
Only 15 lakhs?
15 lakhs. Whereas in central excise and service tax, it is 1 crore, but in customs, it is 15 lakhs. That has not been revised yet.
So let's read the questions.
It's at page 11. Whether in the facts and circumstances of the case, the Honorable Sestas is correct in taking divergent stance on the same issue, that is fulfillment of the condition relating to calcium oxide content under the advance license provisions and consequently to exemption notification. Whether in the facts and circumstances of the case, the Honorable Sesta Kolkata is correct in holding that the eligibility to exemption from the custom duty is still admissible without fulfilling the conditions stipulated in the advance license public exemption notification. My lord, what has happened, my lord? The present respondent has bought calcium oxide, my lord. Imported calcium oxide, my lord. Whereas it is necessary that for availing that exemption, the percentage of calcium oxide should be 54 or more, 54% or more. The Learned Tribunal has initially held that the testing report
Yes, yes.
Yes, ma'am. If your lordship will turn, to page 49.
Hmm.
In the mid of the paragraph. In fact, the appellant want the department to accept the certificate given by Messrs. Mitra SK Private Limited after testing the material at the load port at the discharge port, that is Paradip, in both of which the calcium oxide content have been certified to be at 54.5%. It is not even the case of the party that Messrs. Mitra SK Private Limited followed the methods of drawing as well as testing the principal material as prescribed in IS standard. In our view, this contention of the appellant is entirely untenable. Consequently, we reject all the objections raised by the appellant on the methods of drawal and testing of the sample and the test reports. So the Learned Tribunal has held that this sample, these goods having contents less than 53% of carbon oxide. But if your lordship will come to page 52 there. Para 8 million. Your lordship got it?
You're in OTAPL 10 of 2010.
10 million.
Page 52 is something else, sir. Para 1.3, I'm getting page 52.
Appellate order.
Internal page 11 of the tribunal order.
Tribunal order.
There are two tribunals order. Initially one and another is the impugned one. This is the first order.
Internal page?
Internal page 11.
There are only 7 pages here.
That is the impugned order, Mila.
Ah.
Initially, there is another tribunal order. Your lordship will find it from the Annexure 3. Annexure 3 page, it starts from page 41, Mila.
For us, it starts earlier, but what is internal page?
Internal page 11, Mila.
It's at, for us, it's page 47.
Sorry, Mila.
Yes, it's all right.
It is
I'm
also
extremely sorry.
para 8.
Para 8. It is observed that the commissioner has not recorded any finding on the above contention of the appellants. We are of the view that the appellants cannot be held to have violated the provisions of advance license, DEC book scheme and exemption notification on the ground of non-compliance with only one of the conditions of the license, and consequently on the ground alone, the demand of custom duty cannot be made on them. If they are held to have observed all other conditions of the license, DEC scheme and exemption notification, they should be entitled to the exemption. For want of specific finding on the of the original authority, however, on the other submission of the party, we find ourselves handicapped to pronounce upon their duty liability, if any, on the supposed violation of the condition exemption notification. In this view matter, we are of the view that the case calls for the going back to the original authority for reconsidering the matter and passing a de novo order on the other submissions made by the party below. Consequently, we set aside the tribunal has set aside the order by directing the commissioner to reassess the de novo order.
So what is wrong with this order?
We are not challenging this one.
I know.
We are not
Subsequent
challenging
order. You are challenging the subsequent order.
Subsequent order. Commissioner has recorded his finding that all other conditions in the notification has been satisfied by the assessee, and accordingly allowed the exemption. Against that order, the department
again went to the tribunal.
The tribunal has, without going into the merit of the case, has that as we have already held that this earlier order, that exemption is allowed even if one condition is not satisfied, and as there is no power of review, therefore we are not entertaining the case. Accordingly, the tribunal has disposed of my against which I am before you, Lords.
So what's wrong with the tribunal's order?
Well, the first question I have to reframe it, whether the tribunal has the power to review or not.
No, it obviously doesn't say enumerated power, sir. Unless a specific power, it can't review.
My
No
lord
problem.
my lord knows the case of the board of BCCI versus Union of India and other cases.
That is different. So that's
My-
fraud and all that. That's nothing to do with this. This is a tribunal. It's a statutory tribunal.
And I should, my lord, I should fairly submit that original in the first order, we have not challenged before
Correct.
that order. That finding, it is still there.
There, correct.
But if you see the exemption notification, there are 6 conditions has to be fulfilled. Though the appellant has fulfilling all the 5 conditions, but the main condition has not been fulfilled. That the CAO has to be more than 53%. That has not been fulfilled.
So that's again going factually into it. Yeah. Actually, we'll decline to interfere, so we'll set out the facts. All right. The appeal systems, we'll pass the detail. 42, 43, 44. All right.
Forty-five, Lordship, I have filed an restoration application.
Steps for limitation not taken.
Yes, not the problem is not there. It was a peremptory order was passed. It was not complied, but the department is filed on an extension application that has not been brought to the knowledge of the court. Therefore, my lord, court is passed this order. Your lordship given one chance, my lord.
No. Everything has to come to an end one fine day.
Yes, my lord. Only 3 to 4 days, my lord, I'll file.
No.
Lord,
the appeal itself was dismissed on 14/12/2016 since defects were not removed within the stipulated period. The application for restoration was filed belatedly, and no application for continuation of delay has been filed for the last 6 years. For the last nearly 6 years. So in the circumstances, the court does not propose to give any further indulgence in the matter. The application is dismissed.
46. May I please, your lordship? I filed CMPL for restoration of the contempt, my lord. I filed also limitation petition. That is delay of 30 days, 40 days. Non-compliance of the order. I have filed that contempt, my lord. I have quoted in para 4 of my CMPL, page 2. That is dismissed on 1/11/2016.
No, you made a submission, you have no instructions. This is not dismissed for default.
My lord, till that they not pay the amount, my lord.
No, but you have said you have no instructions, sir.
No instructions on that day, my lord.
No.
But till that, no, we have no instruction to whether he has been paid the amount or not.
All right. We are not inclined, sir.
My lord, only till that they have not paid, my lord. He's a poor
Court
man.
finds no merit in this application. It's dismissed as such. Delay is allowed. Delay is controlled.
47.
None appears dismissed.
48.
None appears dismissed.
49.
Same order.
50.
Same order.
51.
50 also. 51. 50 am. Lord, here, my lord, the question of law, my lord, in internal 6 of the appeal memo. The 2 issue here is involved with the TDS amount, which was deducted earlier, and the deduction certificate received subsequent year, whether the adjustment will be permissible or not. Now, some number 2, my lord, there is a composite contract. One is supply, another is, my lord, service contract. So far as service contract, my lord, I have filed this return under the Service Tax Act, Finance Act, and that has not been considered on the ground that no books of account is produced. Your lordship, see the finding.
All right, we'll just say notice returnable. He accepts notice. All right.
51,
Another question of law is page 10, my lord. At the bottom, A, whether in the fashion.
MC is allowed.
It says the tribunal is legally correct to sustain the order under section 43 without order under section 39, 42 and 44, my lord. So,
Keshav Automobiles.
yes, my lord. That is.
All right. Admit the following question clause frame for consideration. We'll take from A. Question A at pages 10 and 11. In view of the judgment of this court, in case of automobile, the state of Orissa, the question is answered in favor of the assessee and against the department. The impugned order of the tribunal and the corresponding orders of the ACST, First Appellate Authority, and the assessing officer are hereby set aside. The revision petition is disposed of.
52,
52, my lord. I pray for 1 week time to remove the defects.
No, it's a 2018 matter, sir. What's the delay?
Yes, my lord. But I
All right,
conducting
delay is
counsel
condoned.
will
What are
stop-
questions involved? But MC 71 is allowed, 73 is allowed. In STREV, you say notice returnable 10th April. You have 6 notice. All right.
Copy of
Copy we serve.
I'll serve.
53,
Your Lordship, 53, that trade discount, Your Lordship.
The question sought to be urged by this by the revenue in this petition. It's answered against the revenue by the decision of this court in Geeta Shri Industries, State
No,
of Orissa.
That's on pharmaceuticals.
Son.
Today.
Decision dated 6 July 2022 in STREV 25/2013. Messrs. Sun Pharmaceutical Industries Limited versus State of Orissa. Accordingly, the STREV is dismissed.
54,
Your Lordship, page 15, Your Lordship, may kindly. The question of law is that whether in the facts and circumstances of case, cashew kernel is treated in common parlance as dry fruits, falling within the fold of NT 20 of part 2 of the schedule appended to the Odisha Entity Tax Act, Your Lordship. And the same, Your Lordship, also the next question is cashew kernel did not fall within
Not
the
covered already.
No, not covered.
All right. Notice returnable 11th April.
55,
Next is the same, Your Lordship.
All right. Again, notice returnable 11th April. Miss case is allowed.
56,
What's the delay?
May I please? May I please your lordships? Your lordships, I am appearing on behalf of Mr. Bhavani Prasad Mahanti in item number 56, 57 and 63. Your lordship may grant 1 week time to rectify the
Yes, first one.
Yes, sir.
That's the last chance. Delay be removed, defects be removed within a week. This thereafter. Same in 57, 58.
57,
56, 58. Sorry, 55, 56, 57, same. What are the numbers, sir?
67, 56, 57 and 63.
Those three matters. All right.
58,
58, I just pray 1 week time, my lordship, to remove the defect.
Copy has not been served.
Defects be removed within a week. That's the last chance. Let's that out.
59,
None appears dismissed.
60,
60, my lord, in this case, it involves
See, Your Lordship,
interpretation of 2J, my lord, of the Entry Tax Act. Matter which is the vice has been challenged in WPC 14069 of 2012, my lord. This matter may await the result of this. 2J.
5th December.
But that is, I think those are repetitions. This is STRV. So we'll just await the decision.
In WPC 14069 of 2012.
List after the decision in
WPC
Civil
14069
of 2012.
Obligement.
61.
Permitted to rectify the next week defects.
Defects we remove within a week, list thereafter.
62.
None appears dismissed.
64.
64. Your Lordship, the question of law is that page 9, Your Lordship. Whether in the facts and circumstances of the case, the tribunal is justified in determining the computer printed forms are not coming under the purview of scheduled good. For entry serial number 70, part 1 of scheduled goods, Your Lordship. It is the interpretation of statute, Your Lordship.
227 days delays.
Your Lordship.
Leave the question open. The inordinate delay of 227 days in filing the present petition, which has not been satisfactorily explained. Leaving the question of law open for the decision some of the case. IA number 109 of 2018 is dismissed. Consequently, the STRE is dismissed. The 108 is allowed.
65.
65 blood, Your Lordship. Next week. Because I have somehow misplaced my file.
Counsel petitioner states he has misplaced. Will I permit you to revive it, sir? The petition is dismissed for non-prosecution with liberty to the petitioner to revive the petition as and when the file is traced.
66.
Your Lordship, next week.
Whenever you find the file, you can file an application.
My Lord, the question framed at page number 16. Whether in the facts and circumstances of the case, the learned tribunal is legally justified to hold that the implement goods, the job work goods, when the ample evidence of client
MC 722, we say it is allowed. The appeal is taken up today itself. And now the appeal. What's the tax effect here, sir?
More than 2 crores.
2,000?
More than 2 crores.
2 crores.
2 crores. Notice returnable 11th April.
67.
Lord, 67 permitted to withdraw with liberty to file a better application.
All right. Dismisses withdrawn with liberty to file a better application.
68.
May I please, Your Lordship? My Lord, the fire station is running in a particular place where, my Lord, the land alienation process was started and it was completed. Now, my Lord, they are trying to shift it to another place. Your Lordship may turn to the earlier the petitioner had approached this honorable court, and Your Lordship may turn to page 63. Your Lordship directed it was withdrawn with the liberty to approach the authorities. Now, my Lord, Annexure 14, page 99.
Anyway, representations are there, sir.
3, my Lord.
Anyway, your representations are there. The petitioner's representations back Annexure 13 be considered by
opposite panel of 3, my Lord.
Director of Fire Service Odisha, and after giving the petitioners a hearing, a reasoned order shall be passed thereon not later than.
Lordship say after giving
and made available to the party, to the petitioner. The court clarifies it is not expressed.
May I pray, my Lord, till then, my Lord, status quo at least. Because it is functioning in a particular place, my Lord, where all infrastructures are there.
Not really. Yes.
69.
May I please, my Lord? I am on VC, my Lord. My Lord, this is a matter, my Lord. Recently, there is an advertisement for the post of Anganwadi under Khaprakhol block, my Lord, in the district of Balangir, my Lord. This notice was issued on dated 15th May.
It's a service matter, sir. No PIL in a service matter.
But my Lord, here fraudulent activities has been
whatever.
My Lord, the villagers are not on agitations and
other remedies are not PIL. Any other remedy you take. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to seek other remedies available to the petitioner in accordance with law. This post of is withdrawn with liberty is paid. Okay.
70.
My lord, 70, this is a PIL, my lords. This is filed, my lords, against the holding of a Mahotsav, my lords, in a large scale without obtaining any prior permission, my lords, from the authorities. And Annexure 2, my lords, considering our objection under Annexure 1, they withdrawn the permission. And again, 2 days after, on 21/11, they have again granted the permission to hold the Mahotsav without involving the villagers also. Large numbers of villagers are objecting because no permission, no.
As we turn to page 28, Annexure 3, there has been some undertaking given by the Sarpanch of the area. And basing on that, my lords, if I may read that, they say that in inviting a reference to letter number so and so on the subject cited above, I would like to say that taking the undertaking and representation of President Rajsunakhala Mahotsav Committee and Sarpanch Rajsunakhala Gram Panchayat into account and the documents attached in the application, especially forged allegation received on 19/11/22, pursuant to which the NOC was cancelled. After a verbal telephonic discussion with the Assistant Director TE and SCRT Odisha Bhubaneswar and the larger interest of the locality, now it is reconsidered for conducting Mahotsav from 5th of December to 14th of December in DIET playground. The permission will again be withdrawn if the genuineness of the documents are found forged.
Sarpanch is conducting in his own personal capacity, my lords, such a large scale and without any authority also. There will be health and safety and various others they have faced also in 2019. That was first time it was held. Thereafter, no such Mahotsav was held. And now again, they are going to conduct. And because large numbers of persons, villagers at Annexure 1, they have endorsed the objections. They have not involved the villagers. And again, just from the Sarpanch letter, and they are again granting the permission. Collector has also not verified the genuineness of the allegation. Nothing has been done. They are going to conduct this Mahotsav at such a large scale within small premise of the village, my lords. That too within a school premise, my lords. So this is the reply.
Yes, ma'am. That's the Mahotsav is from the 5th.
5th, my lords. They are conducting for over 10 days. They are going to conduct from Monday, my lords. 5th of December.
It's just next week.
It was
Annexure 1.
That Annexure 2, they withdrawn it. Now again, perhaps obviously, there might be some collusion and with some influential persons, and they have just surreptitiously granted the permission. That is our, my lords. What does it involve? This holding the festival involves what? Festivals, they are involving, and they will be creating the shops, temporary shops and all, and alcohols and all, everything will be in black. Where is the location? Where are they holding it? In Ranpur. Malad that is in Rajsunakhala district, Nayagarh.
Within the premises of the school, my lords, the playground.
That is within the DIT school, my lord. That is. It is also not permissible, my lords. Within school premise, and school children will be affected and all. No, how many days, sir? For over 10 days, my lords.
It's from 5th to 14th.
So what happens to school? It's not closed. School is not closed. Yeah, the all working days. Yeah. How can you hold it in a school, sir? What happens to children, classes? Even if it's, is it only in the evenings or it's through the day?
I'll have to take instruction on the.
So notice, Mr. Mahanti accepts notice on behalf of opposite parties. 1, 2, 5. Sarpanch also.
No, it's not.
1, 2, and 5. Notice to the remaining opposite parties. When should we have 5th? Starting the festival, starting on the 5th. They can very well also postpone. Let them first obtain instruction.
No,
is
this
what festival is this? Is it a religious festival or?
There's some. Maharaj may call it once before on the second possible, I get things.
All right. Just 1 second.
71.
Here the copy has already been served, my lord. The short point, my lord, is my appeal, my lord, has been dismissed for default, with notwithstanding the extension of the Honorable Supreme Court in the suo motu division for the COVID-19. My lord.
But why in a writ petition?
Lord, otherwise, my lord, the tribunal is not functioning. So unless I file a writ, my lord, I can't go to the tribunal. My lord. This is a first appellate order. And if your lordship would see, my lord, the order was passed on 21st of April 2020, my lords. Sorry, 22nd of January 2020. And the time limit is 3 months, subject to another 1 month by the commissioner. But all of a sudden, my lord, this particular appeal was filed on 27th of November 2020, my lords. And that, in my humble submission, is much within the second extension, which was prevalent till 8th of December 2021 by the Supreme Court. My lords.
What do you say, Mr. Mishra?
My humbly prayer, my lords.
Can it go back?
Your Lordship is absolutely right, Your Lordship. But the attitude of the petitioner, there was delay.
But the COVID restriction.
There was delay of first appeal. Now, Your Lordship may kindly look into the order of the first appeal. And when the first appeal order has been passed, and when
first appeal order, my lord,
first appeal order has been passed on 31st December 2020. The read has been filed on 31st December 2021. Even Your Lordship.
Lord,
So always
I get time, my lord, till 28th of February 2022 and 90 days thereafter, my lords. Your lordship may kindly. A similar objection was taken by the honorable.
No, I'm not objecting. I'm just showing the attitude of the petitioner.
It should maybe bad, my lord, but still, my lord, the COVID protection is there, my lord. Supreme Court and the honorable your lordship's court also, my lords. They have quoted, my lord, the COVID guidelines, my lord, in the third paragraph, my lords. May I please it, my lords? There was a delay, my lord, and the Honorable Bombay High Court, my lord, had dismissed it. The matter went up to the Honorable Supreme Court, and having heard the learned counsel appearing, the third paragraph, my lord, the first page, on behalf of the respective parties and having considered the order dated 10/1/2022 passed by this court in investigation number so and so, by which the following order was passed, and the order dated 4/1/2022 passed by this court in SLP number so and so in case of Centio Pharmaceuticals, and another was the Stanford Laboratories. The impugned order passed by the High Court is unsustainable. The operative portion of the order passed by this court in miscellaneous application number so and so, and then, my lord, 1, 2, 3, 4, and your lordship may see, my lord, from 15/3/2020, their lordships were considering till 28th of February 2022, and shall stand excluded for the purpose of limitation as may be prescribed under the general and special laws in respect of all judicial and quasi-judicial proceedings. Consequently, the balance
We'll send it back. The challenge in the present writ petition is to an order dated 31st December 2020 passed by the Additional Commissioner of State Tax Appeals, Baleshwar, dismissing the appeal filed by the petitioner. Under section 107 of the Goods and Service Act.
Page 23 is the
2017. Full stop. At the outset, Mr. Kara informs the court that although the impugned order is an appealable one, there is no tribunal in place. Full stop. It is seen that in the impugned order, the appellate authority has dismissed the appeal only on the ground that the appeal was filed on 27th November 2020, whereas the last date for filing it was 23rd April 2020. Paragraph. Counsel for the petitioner points out that this was during the period of COVID-19. And in terms of the orders passed by the Supreme Court, in recognizance of extension of limitation 22 live law bracket SC bracket 31, as further explained by the Supreme Court in its order dated 9th May 2022, in civil appeal number bracket SLP civil 2522 of 2022 bracket Baba Saheb Rao Saheb Kobarne versus Pyrotech India Private Limited 2022 live law bracket SC 520. The SSC has to be given the benefit of the extended period of limitation as a result of the above order of the Supreme Court. Paragraph: the above position is not able to be denied. So stop. Indeed, the Supreme Court had extended the time periods for various kinds of cases where the limitation was going to expire during the period when COVID-19 was active. It's explained in Baba Saheb Rao Saheb Kobarne, Supra. The extended periods of limitation in terms of the Supreme Court's orders, above order, was binding on all authorities. Paragraph. Going by the judgments of the above orders of the Supreme Court, there was no delay in the delay in the petitioner filing its appeal ought to have been condoned by the first appellate authority. Paragraph. Consequently, the impugned order 1st December 2020 of the Additional Commissioner of State Tax bracket appeal Baleshwar is hereby set aside, and the petitioner's appeal, first appeal case number
It's a page 21 minutes.
2000707BX is restored to the file of the first appellate authority and will be listed before him on 3rd January 2023 when the petitioner will appear through an authorized representative. Full stop. It is clarified that the delay in filing the appeal will be treated as condoned by virtue of the present order. Full stop. The first appellate authority will then proceed with the appeal on merits and end as expeditiously as possible. The writ petition is disposed of in the above terms.
Greatly obliged.
72.
Because the defect, as per the noting, may kindly ignored. In the meantime, because I have already solved a copy of my current minutes. That's the only defect you are appearing. Yes, so far as the case of the petition concerned, belongs. Yes, payment of this compensatory afforestation charges. That is the levy belongs under the Compensation of Afforestation Act 2016, and belongs net present value, which is payable under the Forest Conservation Act, whereas to the authority that constitutes a measure of tax. The challenge of the petitioner is belongs to the notice filed annexure 3 on 2 counts. One is belongs, this is sovereign function. There is no consideration so far as the essence of belongs. That is the essence of the basis of levy of tax is concerned. In absence of consideration, there cannot be levy of tax. And if you also will see the consideration, payment of NAV, that's that net present value, NPV, and also compensatory afforestation charges, that doesn't constitute consideration. So therefore, the very basis goes below without jurisdiction. Second is limitation. Perhaps I will elaborate a little while. Perhaps,
what is your prayer?
My prayer is that whereas the notice issued to me, whereas for levy of service tax, that is for the period 1/10/2016.
Which page is the prayer?
That is at page 34, Vilas. Issue rule, I see.
Calling me the hard copy. You have not scanned it after page 24. No, it's complete, sir. Your original petition itself is incomplete.
Page 50, your lordship, page 50, annexure 3.
Annexure?
Annexure 3, page 50.
Is it incomplete, Vilas?
Your lordship came here 564 on 2022.
No.
No, our brief is incomplete.
87 pages, Vilas. I will then complete it.
E31 is coming.
Yes, Vilas. By way of e-filing, I have filed.
He said defects be removed within a week, list thereafter.
73.
Be removed within a week, list thereafter.
74.
The memo is taken on record. The writ petition is disposed of as withdrawn in terms thereof.
75.
My lord, this is a covered matter. 75. Assessment year 1314, 148 notice.
In view of the judgment in Ambika Iron Steel. The order dated 24 January in Ambika Iron Steel. The imputed notice under section 148 of the Income Tax Act 1961 and all orders and proceedings consequent thereto hereby quashed. The writ petition is disposed of.
76.
May I please? In this case, it's happened.
All right. Counsel for the respondent stated to be opposite party stated to be unwell. List on 6th April.
77.
In this matter, I have filed affidavit as per the Lordship's order, that Green Tribunal order, my lord. My lord, I will forego that broiler farming, and my application may be considered for any other project, my lord. The tribunal passing the orders directed that the collector approval is rejected and directed for demolition of an entire structure, my lord. I have invested 40 lakhs rupees because as per the government mechanism, they have utilized, they have given the permission, my lord. This is an online application for the lady entrepreneur, my lord. I have filed affidavit that my application may be considered for any other purposes if subject to my application.
You have to give that undertaking.
I have given. I have filed affidavit.
I haven't received a copy of that undertaking.
Also in the writ petition, I have also paragraph 13 also said so, my lord. That is also on affidavit. Let me see. Page 12. The petitioner can utilize civil construction for any other purpose or any other project as provided by the Odisha government for other banana cultivation, mushroom cultivation as per the scheme, my lord. Mukhyamantri
The
Udyog
liberty
scheme.
can be given to approach the
My lord.
opposite party number
An
4.
affidavit has been filed by petitioner stating that in view of the order passed by the National Green Tribunal, Eastern Zone Calcutta Bench on 18th August 2022 in OA number 66/22/EZ, the petitioner will opt for any other non-polluting project that is other than poultry farming. Paragraph. It will be open to the petitioner, therefore, to approach the state government with a fresh proposal in the above terms.
Well, that part of order, the tribunal order, that part, my lord, also.
Yeah.
Remove all the construction made on the site in question.
Which, if made on or before 2nd January 2023, will be examined, notwithstanding the order dated 18th August 2022 of the NGT. However, provided that it is for a project other than poultry farming.
But they have a projecting online
that thereon be taken within a period of 2 months thereafter and communicated to the petitioner within a week of its being taken.
78.
May it please, my lord. Lordship, may kindly see the order number 7, my lord, dated 16th of May 2022, my lord. The main prayer in the petition is for a direction to the opposite parties to declare Salipur as a notified area council. Mr. Mudili, London Additional Government Advocate, states that although the earlier reply was filed way back in 2017, it is more than 5 years ago. There is need to update the current status and therefore we are permitted to file a supplementary counter affidavit. The supplementary counter affidavit be filed not later than 25th of July with an advance copy to the council. Then Lordship may kindly see order number 8. in the latest affidavit filed on 20th of July 2022, it is
What's the
stated that
position, Mr. Mohanty?
My lord, your lordship, kindly the instruction I have received.
Fresh elections were held in February 2022. New elected bodies have taken over. Formation of NNC would substantially to dissolution of the panchayats much before the completion of tenure.
Recent was held of panchayat and new sarpanch and all PS members.
You have to provide this to the other side.
He is not here.
You have to file it by way of an affidavit, sir.
Oh, yes.
Although
And
written
this
instructions
letter I have
dated 7th
received in-
October 2022 of the Undersecretary to the Government Panchayati Raj and DW Department, Government of Odisha, has been handed over by Mr. D.K. Mohanty, AGA, to the court. It is necessary for the said stand of the Panchayati Raj and DW Department placed formally on record by way of an affidavit. Mr. Mohanty assures the court that the said affidavit will now be filed before the next date.
I am taking back that letter.
But this is
In the said written instructions, it is stated that the report of the collector has been called for. Collector Katak has been called for. The affidavit will enclose a copy of the report of the collector.
And the important part of this letter is that I am directed to say that the proposal we met and the said subject satisfy all the criteria laid down under the provision. So
No, that's not. Then he says if it happens, then it will.
This panchayat election
will not be able to complete the tenure.
Yes. I will file the affidavit with
Enclosing copy of the collector. The affidavit will enclose the copy of the report of the collector Katak.
Well, I can demonstrate, Willard, because of the delay on the part of the government, these things happened. Otherwise, the matter could have been ended in the year 2017. Because they had filed the counter affidavit in 2017, when these developments could not have happened. Because of their delay on the part of the one department writing to other departments becoming senile. All these developments have taken place for that. And it was on 2/5/2017. In fact, the learned AGA had taken time, Malad.
24th January.
24th January. Obliged.
79.
May I please? Item number 79, last one kindly peruse the last order, 9/6/2022. The learned State Council took time to file response to my additional affidavit dated 15/3/2022.
79, I'm sorry. Last opportunity maybe.
The last chance is granted to the state to file an affidavit, additional affidavit. No, file a response to the additional affidavit to the petitioner. In terms of the order dated 16 March 2022 of this court, on or before 2nd January 2023. List on 24th January.
80.
80, my lord, state has not filed counter, which time may be given so that in the event the file counter, I will file my response.
I have received the Parawai's comments. Affidavit.
Mr. Mohanty assures the court that he will file his affidavit within 4 weeks with copies to all the counsel for the parties. We joined that to any file.
$81.
My lord, your lordship kindly see the order dated 28/3/2022. Lordship granted time to opposite party 5 to file counter as well as to the state. Nobody has filed.
Lordship, I am appearing on behalf of OP number 5. Lordship, I am praying for 1 week time to file the counter. Your Lordship, last
we filed within 8 weeks, joined up for the next date. List all.
$82.
Pray for some time, my lord, for filing rejoinder.
Okay.
Two counters I have received, only rejoinder to file.
6 March.
83.
That's 83.
Please, Your Lordship.
Counters have been filed. There's a stay order operating. They have taken time for rejoinder. The school has not been able to be shifted because currently, the school was adjacent to the highway. So there is an expansion of the highway. Therefore, there was a meeting where the villagers were present and all the other stakeholders were present. And ultimately, they decided that there is a school 200 meters away. And within that premises, this school will be primarily relocated. Thereafter, they approached this court and there's a status quo order. So because of this, the highway expansion is also not been able to progress, and also the school is not also been able to relocate.
Already, I am for the opinion number 9, the land acquisition officer. As per the meeting, the total amount has been sanctioned and the construction has already been gone and the plinth level has already been, pillar structure has been made. I have given my counter page 19. Now, because of this, my status order, the further process has not been developed. Now, unless this, your lordship's order is.
My lord, we have received the affidavits, counter affidavits, but I pray for 2 weeks' time to file the rejoinder.
That was last time, madam.
I have filed it in September.
12th September, it's rejoinder time was given.
So, for last 1 week at least.
Then we'll vacate the stay. Yes, we say more time is sought for rejoinder despite time having been granted on 12th September 2022 itself. That view of the matter, while permitting to file a rejoinder before the next date, the status quo order passed with this court on 3rd August 2022 is hereby vacated.
Great.
Less than 6th April.
84.
Millard, in this case, I am for the petitioner Millard. On the last occasion, on order number 1, Millard, dated 20 September 2022, your lordship directed to the Learned State Council to file affidavit. Millard, till now, no activity has been started, Millard. The condition of the road is just it was before Millard. It was in a ruined and dilapidated condition, Millard. And your lordship may kindly have a glance. In this connection, I have filed one IA, Millard. Your lordship may kindly have a glance on para 4 of my IA. Am I be permitted to read, Millard? Page 3, para 4, Millard.
Millard, take instructions on whether the road can be repaired.
Yes, as a last chance, I am seeking some time for filing.
Millard, because all the villagers are farmers, and they start their surplus ready to sell to the government and at the local market, which will start from January, Millard. If before that the road construction work shall not be completed, then they cannot sell Millard, because it is very difficult on their part to maintain their livelihood, Millard. Let a direction be given by which they must complete it within the end of December.
So he's asking for some more time to file, because last time we had asked him to find out whether the road can be completed.
Millard.
Repaired and completed.
Current status of the road, I will inform.
Millard, till now, I am saying that till now, no activity has been started. Nothing has been done, Millard.
If it is not started, as you're saying, then how can it be completed by the end of December? My lord, I will file the necessary affidavit.
Millard, 200, Millard, so far Annexure 5 is concerned, the field inquiry staff, they given report that your lordship may kindly have a glance on Annexure 5
page 41, last paragraph.
All right.
That page 4
Mr.
there.
Mohanty assures the court that the affidavit will be, in terms of the order dated 20th September 2022, will be filed positively on or before 2nd January 2023. If it is not so filed, the project director DRDA will remain present in mode for the court on the next date. 9th January.
85.
May I please? Let's see, here the matter is addition of 1,60,000 under section 69A of the Income Tax Act. So kindly have a glance at page 29 of the assessment order.
Why can't you challenge it in appeal?
Let's say already I have filed the revision, and let's say I have filed a notification of Government of India. Kindly have a glance. So below, I have flag mark annexer 1.1. Let's say in case of an individual other than minors not having any business income, no further verification is required to be made if total cash deposit is up to 2.5 lakhs. So here the amount added is 1.6 lakhs. And here the petitioner is a doctor. And so far as the act is concerned, let's say.
What happened to your reply?
Same point he has taken in the reply, in the counter affidavit also. At page 2 of the counter, same thing he has taken as per my submission, let's say. Paragraph 5, subpara. The facts of the case is that the petitioner had filed her return of income for assessment year 2017-18 on 29/11/2017, disclosing total income at 9,10,190. And assessment under section 143(3) of the IT Act was completed on 28/11/2019, determining the total income at rupees 10,70,190. So 1,60,000 under the head of unexplained money under section in A. So 16A, you let's say, page 29 in the assessment order also, it is explained. Section 16A, you let's say. May I place the section, let's say?
Yes.
Page 29, it is reproduced in the assessment order. So wherein
what is the urgency in this matter?
Your Lordship, it's only matter of 1,60,000, and only the Government of India notification is there below 2.5 lakhs, that there will be no explanation.
Since there was no pleading, my lord, in the writ petition,
already
no answer on this.
Already
you quoted this circular in the pleadings.
No. Only on the point of law, your Lordship, 69A speaks that if I'm placing your Lordships.
No, if you're relying on this, let him give instructions.
No, already I have in the last occasion also, I have relied on that in notification, your Lordships. At the point of assessment proceeding also, that was there. But 16A speaks that if the article is not recorded, but it is recorded in my bank account, and 26A is also, it is there.
No, that found
so,
differentiate, my lord.
No, 1,60,000.
1,60,000.
That is my point.
That has not been explained in the books.
Your Lordship, 16A speaks that if article is
29, Lordship can have
that page I am placing, your Lordships. 69A speaks wherein any financial year the assessee is found to be the owner of any money, bullion, jewelry or other valuable article, and such money, bullion, jewelry or valuable article is not recorded in the books of account. And in the bank statement, it is already there. 26A is already there, and I am a salaried employee. So if any maintained by him for any source of income, and the assessee offers no explanation, but explanation is there in my written submission, page 20.
That is, my lord, with regard to the amount which has been found to be correct, my lord, in view of the books of account. But the difference amount, which is 1,60,000, that is not available, my lord. No explanation was
kindly have a glance at page 28.
69A, my lord.
Page 28, last para. That cash which remains unutilized after withdrawal is again deposited in cash, which is quite obvious to avoid interest on loan taken from bank for construction of residential house. So that amount I have taken from the bank, and in that at page 48, they have calculated the same thing. 48, your lordship, the revision order. Everything is there. So 38 2016 1 lakh, 16/9 2016 60,000. This is the impugned amount, your lordship. 6.2 paragraphs specifically says that thus it is seen that AO has accepted the source of cash deposit. So he has accepted the source of cash deposit on account of cash withdrawal, on account of cash withdrawal from bank on 6/10/2016, 11/2016 of rupees 1 lakh and rupees 85 lakh respectively. However, he has not accepted that cash withdrawal of 1 lakh and 60,000 on 38/2016 and 69/2016 respectively. So 185 he has accepted, 160 he has not accepted. To that, no reason he has stated. And it is found that AO has been very reasonable in accepting the claim of the assessee. So matter of 1,60,000, and he has accepted that I have withdrawn from my account. The question remains that on this background of cash withdrawn earlier period has rightly been rejected. Why I have withdrawn from my account, it is accepted. But why I have again put it in my bank account, that is the rejection ground. Let's say. Only 1,60,000.
1,85,000, which was earlier withdrawn, my lord, that has been deposited, that has been taken into consideration, my lord. The 1,60,000, which is the disputed amount, that is not the source, my lord, where it was withdrawn. For that has been rejected. Lordship, kindly see the last two lines of the said order. On this background, cash withdrawn earlier period on 38/2016 and 69/2016 as rightly rejected, forming the cash deposit of on 19/11/2016, 13/11/2016 and 1/12/2016. My lord, these withdrawals earlier, my lord, that
what do you say to this circular?
My lord, on that, my lord, I have to take instruction.
So it is
because approval was taken or not, my lord, that is the new.
No, it is not. 2017. And so far 69A
approval or
lordships, their own order at page 48, that is revision order, they have accepted amount, date of deposit and cash withdrawn. Everything is reflected there also.
No, regarding taking approval with regard to below 10 lakhs, on that, my lord, I will take instruction.
10 lakhs, 1,60,000.
1,60,000, sir.
Only.
No, below 10 lakhs. Approval is necessary.
2.5 lakhs.
Yes.
Yes.
At the outset, Ms. Roy Chaudhary places before the court copy of instruction number 3 of 2017, 21st February 2017, issued by the CBDT. Full stop. The annexure sets out the annexure to this instruction is a source specific general verification guidelines. Para 1.1 of the said annexure states that in case of an individual not having any business income, no further verification is required to be made if total cash deposit is up to rupees 2.5 lakhs. Paragraph: in the present case, what is sought to be added to the income of the petitioner assessee is a sum of rupees 1.6 lakhs. Full stop. Accordingly, it is submitted that no such addition was warranted in terms of the said. Mr. Mahapatra, standing counsel for the department, seeks time for instructions. First February.
86 counter file today, my lord.
I've just received the copy of the counters which my learned friend has filed.
All right. Counter affidavit filed with the department will be placed on record, rejoined for the next date. Interim orders to continue.
Interim orders to continue. In all the cases.
6th April.
87.
May it please your lordship. My lord, this issue is relating to certificate issued for deduction of tax at source under section 197 at a rate of 1.25%, my lord. I am challenging that on the ground that it should have been nil because it is relating to the agreement between the petitioner and the Hindustan Unilever at Annexure 1, my lord. And that agreement is purely a purchase agreement and doesn't come within the definition of the work contract under section 1, explanation to section 194C. Lordship, may kindly see page 41, the agreement.
You're not filing any rejoinder, are you?
My lord, I have filed the rejoinder.
No, it's not on record, sir. The rejoinder filed by the petitioner to be brought on record. It's for hearing on.
Not on board, my lord? Rejoinder not on board?
Not on board. Just check the paperwork.
My lord, OP5 is filing a list of citations. Let that be kept on record.
My lord, your lordship is holding 2020, my lord. That rejoinder has been filed.
Oh, that is it? I see. The concept of the petitioner says that the rejoinder filed in WP Civil 30312 of 2020 be treated as rejoinder in all the other petitions as well. In the other petition as well. List for hearing on. You see, the list of citations by OP number 5 is taken on record.
Yes, my lord, OP 5.
Given it?
Given. It is actually squarely covered by Madras High Court ruling, my lord.
27th March.
My lord, I pray, my lord, earlier date, my lord. My lord, in January, my lord, I pray. Please, my lord, two assessment years, my lord, 2021 and 21-22, my lord, 2 financial years, my lord. I pray, my lord. In sometime in January, my lord. It will not. It is covered by your lord's judgment and Delhi High Court, my lord.
27 January.
All right.
88.
Yeah, covered matter, my lords. Covered change of opinion. And they impliedly agreed in the counter affidavit. They have admitted. Lordship may kindly see the counter affidavit. I will not place my repetition. The counter affidavit is sufficient to demolish their case. I'll just take your lordships to para 1. Opposite party submitted that the original assessment order under section 143(3) was completed on 13th of December 2018 on assessee. Total income at rupees nil. On perusal of assessment order dated 13th of December vis-a-vis the notice under section 142(1). A detailed question was served on me, my lords. That they are referring it. It is seen that the issue of development fee of rupees 69 crore 57 lakh 67,000 was not covered under the 19-point questionnaire, and therefore they are reopening. And the assessment was completed threadbare scrutiny assessment.
No, but long not gone into, sir. It was not gone into in the original assessment. It is not part of the original questionnaire. The issue of development fees.
No. My lords, may kindly see the questionnaire.
No. What you read just now, it is seen that the issue of development fees.
That they allege, my lords. But I have enclosed the notice under Annex 3. And moreover, the tribunal, the scrutiny assessment was completed on 13th of December 2018, my lords. This was subject to revision, under so much revision by the commissioner. Commissioner set aside.
Was the issue of development fees addressed in the original assessment order or not?
Yes, it was there. My lords may kindly see. May I take your lordships to 2 minutes?
Yes.
I'll not detain your lordships more.
Lordship may kindly see the ITAT order that is at page 57. Lordship may kindly see.
Yes.
Yes.
57 is Annexure 9.
Yes, sorry.
Not the assessment order.
Yes. The tribunal order, Lordship may kindly see. Tribunal order, tribunal order.
Assessment order, Annexure 4.
Page 57.
Annexure 4, 26.
ITAT order.
57 page.
No, you have to show us that in the assessment order it was considered, sir.
It has been considered by the assessing officer. Question was given.
Show us from the order, sir.
Yes, I'll show it.
Annexure 4 seems to be the assessment order.
Yes, 26 is the order of assessment. A return of income 1617 was filed by the SSC Trust on 15/10/2016. My lords, I'll take your lawsuit that is not relevant to the next page, page 27. Notice under section 143 bracketed 2 issued to the SSC by the predecessor DCIT exemption Bhubaneswar for compliance on 18th of October 2017 and 142.1 compliance on 19/7/2018. Thereafter, notice under section 142.1 read with section 129 was sent to the SSC along with questionnaire on 4/7/2018, fixing the date of compliance on 19.
So we're not able to find. I'm not able to find anything on development fees. Are you? No, not able to find anything on development fees.
Yes. I'll just now. Lordship, just kindly bear with me for 3 minutes.
5 minutes.
5 minutes, madam. Very good. ITAT order. ITAT order. 57. ITAT order. Balance. This assessment was subjected to revision under section 263 matters. Then what the tribunal did matters. Lordship, I challenge the order of the commissioner before the ITAT. And tribunal matters may kindly see at page 57 to Annexure 8A, 74 matters. Lordship may kindly see. Para 6 at page 61. The learned CIT exemption head AO has failed to make proper inquiries on the above issues before passing the assessment order. Therefore, the order.
1 minute, sir. Page 61 is something else.
61, my lords.
Yes.
61. 61.
Note on e-proceeding. That's what is 60 and 61.
My lords, I think the paperwork that perhaps last you may see my brief. (61) and 62, my lords. Both the pages.
Something else is here.
(62) also. The SSC has produced all the.
You've added one 8A subsequently, sir.
Yes, and your lordship on 2/7 allowed the consolidated writ petition.
Where is that?
Yes, consolidated petition, my lords, is there. I have filed it, and it is there also on the record, my lords.
Let's see.
Yes. I'm very careful, my lords.
So what has happened is they've put it separate end.
Yes, that is my mistake. Yes.
My lords may kindly see. I beg apology, my lords. Lords may see. 61 and 62.
Computer page 1.
Finding of the tribunal.
Computer page 158.
Beg your pardon?
Just give this minute.
The tribunal, my lords, thoroughly discussed para 6. Then your lordship may turn to the next page 62. We have heard the arguments of both sides, carefully considered the materials placed on record of the tribunal. The learned heir drew our attention towards notice dated 24th of March 2021, para 5 and 6, submitted that the CIT exemption Hyderabad has pointed out the discrepancy, improved scrutiny assessment order dated ete passed under section ete 143(3) of the Act. He further pointed out that para 6J of the said notice, the CIT exemption alleges that the statement of income shows that the SSC trust has received voluntary contribution, including anonymous donation, which is your lordship has just now read in the counter affidavit, that this was not in the questionnaire. 70 crores, 19 lakhs, 70.
We'll hear it finally on some day, sir. We'll
Yeah.
hear it finally.
Beg pardon?
This won't get over like this. We'll hear it finally on some day.
As your lordship, please.
List for final hearing on 17th April. Interim order to continue. Right.
On which date, my lord?
17th April.
17th April, my lords. It will be hot, my lords. And my lords,
Fortunately, the court is air conditioned.
But while coming to the court, it will be dangerous.
Hybrid hearing.
Hybrid is there. But God has saved me, my lords. The notice is dated 31st of March 2021.
Okay.
Had it been on 1st of April,
I know.
then
148A.
again, that's
Chakraview.
Chakraview. I have been saved.
89.
More time to file counter.
Yeah, that I've said. In 89, we file within 8 weeks rejoinder for the next state.
Interim order is there.
Interim order to continue. 18th April.
That's item 90 is for final hearing. It will take some time.
Right. At the request of counsel, senior counsel, the petitioner. List on 19th April. Interim order to continue. Is there an interim order? There is no interim order.
Don't think there is an interim order. No, there is an order subject to result of the writ application.
That's okay. That's over. That's all.
Oblige.
Just simply say 93. Weekly list.
Going to 4 o'clock. Secondly, still lordship may not take. I've got few matters, my lords.
Which matters? Anyway, we'll just call it off. There are some matters which can go. That's why.
Weekly list. Item 1.
Yes, item 1, my lord. Similar matter has already been decided by this honorable court. I am.
Just get that.
Copy may be given because I don't have the brief. Copy may be given.
Because earlier, my lord, in this case, this honorable, the honorable apex court goes against the petitioner.
All right. See, in view of the order passed by the court on 6th February 2019 in TREV number 231 of 2001, bracket Messrs. Mineral and Metal Trading Corporation of India Limited versus State of Orissa, the present revision petitions are disposed of in the same terms. In other words, the order of the sales tax authority is quashed and set aside, and the matter is remanded to be dealt with in the same manner as indicated in the said judgment. Same order in 2 and 3.
Yes.
Add-on 4. May I please, Your Lordship? Your Lordship, in this connected matters, STRB 86, 87, 88, and 89. So I am appearing. So in the first matter also, I am filing this Vakalatnama. I may be permitted to argue. I am prepared.
Yeah. Please.
Your Lordship, this question of law is at page 7. A. Whether in the factual position coupled with the settled position of law in the matter, the law tribunal is correct to hold that the deductions towards labor and service charges can be limited to 34% in the first year of the project work, which is to be completed within 5 years. B. Whether in the fact and circumstances of the case, the law tribunal is correct to hold that the petitioner in execution of contract work has received any amount towards higher charges. Then C, my lord, whether in the fact and circumstances of the case, the law tribunal is correct to remit the matter back to the assessing officer for recomputation with an observation that the petitioner has ever received any amount towards higher charges. The C has a nexus with the B. So I'm placing the first A, Your Lordship. So, Your Lordship, here the petitioner is a works contractor, and the petitioner has been backed with the contract for construction of a river barrier over river category in Naraz, Your Lordship. The first year of assessment is 96-97, Your Lordship. For execution of works contract, whatever the manpower machinery is a purely mechanized contract, and taxable turnover as defined under the Orissa sales tax law is the gross amount received and receivable less the amount towards labor and service charges. What has happened, my lord, so far as the deduction allowed towards labor and service charges, so that was made by the assessing officer by relying on the vividly verified by the books of accounts, and the assessing officer has came to the conclusion and derived the taxable turnover after accepting my books of accounts. Your Lordship may kindly have it turn to page 3 of the assessment order and on page 11. Assessment order.
Yes.
Being noticed, the dealer represented through its accounts officer so-and-so and the loan advocate so-and-so before me filed Hajira and produced the books of accounts containing the contract ledger, copies relating to the purchase and utilization of materials, particulars of payments to the laborer contained in wage register, muster roll, measurement books, purchase invoices, balance sheet, trial balance, quantity of work done statement, copies of the running account bill, statements showing the purchase of tax-paid materials, material utilization certificate issued by the contractor, as well as the written submission. Then, Your Lordship, turn to running page 18, internal page 10 of the assessment order, Your Lordship. Page 9. Internal page 9, page 17 of the assessment order, Your Lordship.
Yes.
It's labor. So second under the category of labor, the observation of the assessing officer is, in support of the expenses on account of labor, the contractor has produced the wage register, muster payment vouchers, and copies of the trial balance to adduce its claim. No anomalies detected, Your Lordship. The AO has found it. No anomalies detected in respect of any payment made, and the figures in the trial balance agreed with the ledger balance of the contractor. Then accordingly, he allowed my labor and service expenditure. And in the page 10 also, Your Lordship, then the last para, yes, categories the assessing officer has categorically mentioned in the services of the assessment. Page 10 of the assessment of the last para. As regards the expenses related to services, the claim such as set out below is put forth by the contractor as being the deductible from the gross payment. Accordingly, the labor and service charges have been quantified by the loan assessing officer by vividly examining the books of accounts. Accordingly, taxable turnover is determined. Then certain expenditures were disallowed. Then I went on the first appeal, and the learned first appellate authority in running page 33, page 6 of the internal page of the first appeal order, running page 33, my lord. The last part 1 para.
Yes.
As such, the first appellate authority.
Yes.
I do not find any irregularities made by the loan STO allowing the deduction towards labor and service charges to the appellant as claimed by the. So, being the extended form of assessment, the first appellate authority has got the scope to examine the detailed books of accounts and came to the conclusion that whatever the assessing officer allowed is correct. Then the state went to the tribunal challenging this admissibility of deduction towards labor and service charges by both by the assessing officer as well as the assessing appellate authority. Then the relevant observation of the learned tribunal is that page, my lord, internal page 19, running page 58, my lord. The last 4 lines, my lord, of the tribunal's order. In page 19, my lord. The learned SR.
Yes.
The learned SR drew the attention of this forum to the percentage of labor and service component and materials involved in the work as mentioned, your lordship kindly mark it, as mentioned at page 43, clause VIIE of the agreement signed between the contractee as well as the respondent contractor, which is exactly extracted as follows. That clause has been extracted by the Lord of Tribunal. The following points will govern the price adjustment for the entire contract. The my lord, that breakup has been given. Labor is 25%, cement is 17%, steel 25%, POL 9%, other material 24%. So these that constitute 100%. So these clause, only that clause is valid for the purpose of calculating the price variation, that escalation. And whatever the components set out in this percentage method, these components are the relevant factors for calculating the escalation, because though it's constitute 100%, because the contractor, while executing that involves also service charges, overhead charges, profit, those clauses are not here only. And this Law Tribunal has never said that my books of accounts are not worthy of credence. Now in the second para, your lordship, after that, as agreement stands, the work is to be completed within a period of 6 months from the date of issue of letter of commencement. The respondent dealer might have incurred more expenses towards labor and service charges during the first year of work, but to be rational and in order to keep a parity of this,
then you can have estimation. All right. This is one. Then
so that estimation, your lordship. So they have resorted to the clause of the contract, which is irrelevant the purpose of determination of taxable turnover, your lordship. And moreover, under the worst contract, the taxable event occurs on the transfer of property when the goods are incorporated following the principle of acquisition, as I have set out within the Honorable Appeals Court in the Builder Association case, your lordship. Then, just for your lordship's kind attention, your assessment order kindly go, your lordship may go to internal page 16 of the assessment order, running page 24, your lordship. This is material, because ultimately tax has to be levied on the transfer of property in goods. The last para is material, your lordship.
Yes.
The executive engineer Naraz Barrage Division, Cuttack, has issued certificate showing the value of materials incorporated in the works executed by the period so and so. This is the relevant assessment. The extent of material used and the value thereof has also been reflected in the said statement. So whatever the materials has been incorporated and utilized during the year, your lordship, so that has been also certified by the principal. So what is the question when my books of accounts has been vividly examined and my labor and service charges has been quantified, keeping in view of the ratio laid down by the Gannon Dunkley in 88 STC, your lordship. So the assessing officer also laid on this Gannon Dunkley judgment. So what are the expenses which constitute labor and service charges, your lordship? And in the base running page 25, your lordship, that exactly sand, aggregate, cement, all the quantity as well as value, that has been also certified by the concerned principal during the impound period, your lordship. So the taxable turnover has been determined relying on the judgment of the Honorable Apex Court in the case of Gannon Dunkley, so far the component of labor and services concerned, as well as he has considered the whatever the material has been transported, utilized by incorporation of the goods during the impound period, that was certified by the principal. So how the irrelevant clause, that clause is we have agreed on a condition that escalation price will be calculated governing those formulas. It has got no relevance with the quantification of the taxable turnover as well the taxable event, because on those whatever the clauses the Honorable Tribunal has relied upon, there is no such mention regarding services, there is overheads, those are profits, those are not the factors for those things, but that all those constitute 100%. So mechanically they have traveled beyond those jurisdictions.
Yes. Yes, Mr. Mishra.
Your lordship, already my lord and friend is shown that clauses of the agreement, only that is there. Your lordship, as per that clause.
No. Where's the question, sir? The entire books of accounts are accepted to have an estimation and say it will be 34%. Labor and service charges.
That's right.
Can you do that best judgment assessment?
When books of account are accepted.
No, Your Lordship. Also, Your Lordship knows that 4B, insertion of 4B, even 4B says that where it is not ascertainable.
It is not that period.
But yeah, Your Lordship, that also it is not ascertainable, then that is applicable. But here, prima facie, the books of accounts have been verified, and as per the books of accounts.
4B also states regarding acceptance of books of accounts.
Yes, I'm saying that where it is not ascertainable, I'm saying that.
Finding of fact is very clear.
Your Lordship.
All right. What about this? Is
Your Lordship, my
question B
second
and
point.
question C?
Question C. Your Lordship, what has happened here, Lordship? So far, the question B and C is relevant because in the assessment as well as the first appellate authority, they have examined thoroughly the books of accounts. Again, for this allegation regarding the higher charges, Your Lordship, so I may take the Lordship's attention to page running page 61, internal page 22 of the tribunal's order, Your Lordship.
Yes.
The state has raised an additional ground before this forum about the receipt of payment of 1 crore 34 lakhs by the respondent towards higher charges of equipments and machineries. About admissibility of such, because that admissibility of new ground was agitated by this respondent, so that the tribunal held that by relying on the judgment, no additional grounds can be entertained at the time of. Now, the running page 62, internal page 23, Your Lordship, the tribunal held that in second paragraph, we also feel that the omission was not wanton and willful in the present case, but an advertent omission as claimed by the Lord SR. That means SR has never agitated. Simultaneously, Your Lordship, we like to mention here that the respondent dealer has disputed not to have received any amount or entire sum of 1 crore 34 towards the higher charges of the equipment and machinery. So when the state has come up with an additional grounds, they must have given showing some prima facie evidence. Yes, we have received. When my books of accounts, because I am working under single principal, and whatever the amount from the executive in Naraj Barrage division, so that is rightly reflected in my books of accounts. And whatever the metal component is there, that is also sorted out, that concerned executive engineer has also certified. So where from the question of higher charges received during the informed period. So they are simply on the assumption basis, they draw the attention of the court, and court, although the respondent dealer disputed those things, court simply remanded without seeing any prima facie materials to that effect.
All right. Your Lordship, that is a paragraph, page 62.
Yes.
Page 62, Your Lordship, it is evident from the record that the respondent dealer is confused in disclosing his gross turnover and taxable turnover on the face of the return filed even for the third time. He has at the first filed the return which have been revised subsequently, and again the same are revised for the second time at the stage of assessment. Even on the face of the second revised return, the respondent has erroneously filled up the column showing the expenditure towards labor and service charges and so on, so and so. Now, Your Lordship, for that reason, Your Lordship, the 34%.
Actually, that is, the next sentence is wrong. Considering all these facts, the STO rightly rejected the books of account.
Your Lordship.
Actually, no rejection was there.
Rejected to be.
I don't think the STO rejected the books. In fact, on the contrary, accepted the books of account. That's true.
As well as the first appellate authority also.
Yes.
Your Lordship accepted the books of account.
I don't know where they get all this from.
Regarding higher charges, no documents were very added.
Higher charges, Your Lordship, page 62, we also feel that the omission was not wanton and willful, but on the advertent omission as claimed by the law, and simultaneously we like to mention.
That omission was regarding incorporation in the grounds of opening. These are the additional grounds. That's why they got.
Yeah. All right. You see, admit the present revision petition was admitted by the present revision petition arising from an order dated 10th November 2003 of the Orissa Sales Tax Tribunal, Tribunal, in SA number 1111 of 2001-02, filed by the department. Whereby The matter was remanded to the sales tax officer bracket STO for re-examining the issue concerning labor and service charges and amount allegedly received as higher charges by the SSC for the year 1996-97. Paragraph. While admitting the present revision petition on 3rd March 2005, this court stayed the operation of the impugned order and the consequential proceedings as per notice dated 18th March 2004. That interim order has continued. Paragraph. The following questions are framed for consideration by this court. Take from page 7, internal page 7, A, B, and C. Paragraph. Background facts are that the SSC, the petitioner SSC is a construction company and was engaged by the state of Orissa for construction of a water barrier over river Katjodi at Naraj, Katak. Stop. The petitioner was duly assessed for the assessment year 1996-97 under section 12 bracket 4 of the Orissa Sales Tax Act bracket OST Act. Stop. An assessment order was passed on 28th March 2000. Determining that a refund of rupees 4663,222 was due to the petitioner against the claim for rupees 539859 already deducted at source during the execution of the works contract. Full stop. According to the petitioner, it had to undertake a substantial amount of labor and service works in the process of executing the aforementioned contract. Stop. Paragraph. Since the STO allowed only rupees 4663 to 322 as a refund, the petitioner preferred a first appeal being before the Assistant Commissioner of Sales Tax bracket ACST, Katak 2 range, Katak. Stop. This appeal was dismissed on 28th August 2001. Stop. Thereafter, the petitioner applied for refund under section 14 of the OST Act. Stop. At that stage, the state filed a second appeal before the before the tribunal, challenging the dismissal order of the first appeal. That's how can the first appeal dismiss the appeal of the SSC? How can you do not agree with the dismissal order of the SSC? You do not challenge. Against the dismissal order passed by the first appellate authority. Paragraph. On two aspects in the impugned order, the tribunal has remanded the matter to the STO Stop. First, on the issue of labor and hire charges, tribunal came to the conclusion that it would be judicious and reasonable to limit the labor and service charges to 34% of the gross bills received towards execution of the works contract. Full stop. Secondly, for the first time, the state raised an additional ground before the tribunal regarding alleged receipt 1.34 crores by the petitioner towards higher charges of equipments and machinery. Full stop. Although the SSC disputed having received such an amount, the tribunal considered it necessary to remand this issue also to the STO. Paragraph. This court has heard the submissions of learned counsel of the parties. Paragraph. The tribunal has, in the impugned order, referred to clause Roman capital 7 bracket E of the agreement signed between the state and the petitioner, where certain percentages are indicated against labor, cement, steel, POL, and other materials, and observed as under. Take from internal page 20 of the tribunal's order, the line beginning as agreement up to the agreement. As rightly pointed out by learned counsel for the petitioner, the above percentages were indicative of the escalation that was permissible on these items in terms of the agreement and did not reflect on the actual expenditure incurred on the ground of labor and services. So, on the other hand, the books of account produced by the SC were accepted as such both by the STO as well as the first appellate authority. Stop. They examined the books of account thoroughly and found that these were properly accounted for, that the amounts were properly accounted for. Full stop. In fact, the STO also noted that the SSC had produced open quotation labor payment register, vouchers, cash book, master rolls, and copies of the trial balance bracket audited in 1996-97. Unquote. With both the STO and the ACST having accepted the books of account produced by the SSC without any reservation, there was no occasion for the tribunal to have limited the labor and service charges to 34% and not the actual amount incurred. Full stop. The said conclusion of the tribunal is based on a mistaken notion of what clause 7 bracket small e of the agreement stood for. Full stop. There was therefore the tribunal fell into error in limiting the labor and service charges deduction on account of labor and service charges to 34%. Paragraph. Question A is accordingly asked in favor of the SSC and against the department.
Your Lordship, so far as the order of the tribunal, Your Lordship, so far as the estimation is concerned, Your Lordship has determined that since the books of accounts has been accepted, Your Lordship, what happened here, Your Lordship? Two orders, one assessing officer and another is the first appeal order. So first appellate authority also perused the books of accounts and reduced, Your Lordship, the allowance, so far as that allowance, Your Lordship. So what my humble prayer is that
first appellate authority simply affirmed the order of the...
No, Your Lordship. He has reduced, Your Lordship. First appellate authority, Your Lordship.
Noted. How can he reduce in his appeal?
No, Your Lordship.
In fact, he is not aggrieved by that at all. He was only aggrieved saying my refund must have been a greater amount. The refund has been reduced.
Refund has been reduced.
That has nothing to do with labor and service charges. He went in appeal, sir. So in his appeal, there was no occasion to interfere with the STO's order.
Your Lordship.
As far as the second issue concerning higher charges purportedly received by the SSC, the fact remains that no material whatsoever was produced by the department to substantiate even prima facie that the SSC had received that amount. Full stop. In fact, the tribunal notes that the SSC disputed having ever received such an amount. Full stop. There was accordingly no occasion again for the tribunal to have remanded this issue to the STO for determination. Full stop. Consequently, the court answers questions B and C also in the negative, that is in favor of the petitioner SSC and against the department. Paragraph. For the aforementioned reasons, the impugned order of the tribunal is hereby set aside. And the revision petition is allowed in the above terms. Now, what about the remaining connected matters?
Your Lordship, relying on the first year's observation by the Law Tribunal on the subsequent of assessments, the appellate authority has enhanced my, again, relying on those things, Your Lordship, in 86, STRP 86, Your Lordship, we kind of have a glance to first appeal order. Running page 46, internal page 7 of the first appellate authority.
Oh, so here the first appellate authority himself reduced.
Yes, he relied on the views taken by the tribunal.
All right. You see, in these 4 revision petitions, the challenge is to the orders passed by the tribunal, Orissa dismissing the petitioner's appeals against the orders of the first appellate authority pertaining to the assessment years. Give us the years.
Subsequent periods, Your Lordship, is 97, 98,
97, 98, 98, 99, 99, 2000 and 2000-2001. Paragraph. The orders of both the first appellate authority and the tribunal on the issue of labor and service charges as well as higher charges.
Higher charges was in the first year the state has agitated.
Not in the others.
Periods, not in other pockets.
Okay. Labor and service charges triggered by the order passed by the tribunal for the year 1996-97. Both the issue regarding labor and service charges has been decided by this court by a separate order passed today in STREV 35 of 2004 for the year 1996-97 in favor of the petitioner SSC and against the department. Paragraph. In that view of the matter, the impugned order of the tribunal, impugned common order of the tribunal, and the corresponding orders of the first appellate authority for the aforementioned subsequent assessment years 1997-98 till 2000-2001 is hereby set aside.
Let the refund may be disposed of in the timeline manner because the refund flows from this order.
All right. The refund applications of the petitioner will now be disposed of as expeditiously as possible by the department in accordance with law in any event not later than 12 weeks from today. All right. Now, what is this? Actually, there are more revision petitions further down. No. Only up to 89, right?
Obliged.
Item number 5. Item number 5.
Yes, please. None appears dismissed.
6.
Is it short, big, what?
May take some time, but
All right. All right.
Right.
All right. All right. Fine.